arbitration for any disputes that come forward. And then it defines in the applicable disputes section what kind of disputes we're looking at. I won't go into details with those, but it gets into a lot of those. And then, of course, now it defines what they are. It says who may initiate the resolution process to get arbitration going and what needs to happen, the percentages that need to be there. Then the next section is how an arbitration process is presented. So this is how then it's brought to the SREC through a written submission and the RPT secretary with the names, the concise statements, the background, all the other information so that the SREC can take it up. And then we have the role of the SREC, and there will be members selected basically from the entire SREC that will act as the arbitration panel to resolve the dispute, and it explains all of that. And then you have the mechanisms for resolution, how all of that's going to take place, and there's a lot of pieces in there. Like I said, I'm not going to go into that. You can read it. And then the section on final ruling or other disposition, again, that arbitration panel can make those determinations and put that forward. And there's also a couple of other pieces there, a section on motion for reconciliation, and then the enforcement of the ruling itself, and then some miscellaneous, and then a glossary to define what the RPT is, the SREC, county chairman, etc. And with that, Mr. Chairman, I would move that we adopt this.
Anyone else to speak for or against? Seconded was Chuck Burnett. You already did. I'll give you guys like a minute to look it over.
Quick point of information, Mr. Chair.
Yes.
Maybe I missed it. Was this reviewed and approved by
Never mind, I found it.
our lawyers? Does it look good to them, or has it not been?
It has not been reviewed and approved by a lawyer from the party. My understanding is that it was submitted to a committee member by Jim Pickle, who's an attorney.
Mr. Chairman, I think I can answer that question, Andy LRSD 24.
Go ahead, Andy.
And yes, this has been reviewed by multiple attorneys through Jim Pickle's firm.
What they say.
Mr. Chairman,
Yes.
I'd like to speak against the amendment in this fashion. I would
Who's
be
speaking right now? Sorry.
Dave Wilson,
Okay.
SD11.
No problem. Thank you.
I would speak against this rule for the fact that it hasn't been sufficiently explained to me anyway as far as why this is necessary. I'm not saying that it's not, but I don't know the circumstances behind why the arbitration process is necessary as opposed to what we currently have. So until that happens, I'll be a no.
Okay. Thank you. Anyone else? Go ahead.
Yeah, so my understanding here is this is meant to be an alternative to the going to the courts. So the current process is going to court, and that involves, each side hiring attorneys, paying them a lot of money, going through what can often be a very long process, which, in some cases could take years to resolve. And by the time anything is actually resolved, quite often the underlying dispute, right, is moot by then. It takes that long sometimes to get to the merits in a lawsuit. So what this is intended to do is have a process that everyone's agreed to in advance by becoming a precinct chair or a county chair or a party official, and being heard before a body of our peers, right? People who are also party leaders who understand the way our party works and can get into the merits of the dispute fairly quickly and resolve it fairly quickly, and in a way that's less taxing on the parties to the dispute, both in time and treasure as well. Thank you.
Thank you. Anyone else?
Mr. Chairman,
Yes.
I'm Beckmeyer, SD 31,
Go ahead.
and I want to speak against this once again we're getting things further and further away from the grassroots origins of this party and what we're trying to maintain. That's one point. The other point is you almost have to be a lawyer to understand this. The next point is, as a SREC, anyone that's on this committee, I'm not sure that you want what you're asking for here. And so I understand the basis of this, but it's a bad idea.
Thank you. Anyone else?
Point of information, SD19.
Yes. Go ahead.
Does this create a, reading this correctly, does this create a mandatory arbitration clause basically that says you have to do this for all precinct chairs?
And what language are you looking? Yeah, it's the rule states the rule compels final and binding arbitration for any dispute listed in the amendment. Yes.
Josh Flynn, SD15, point of information. Does this now make it not possible for us to go to court? So this is like this arbitration thing we put in here. We could be guaranteed we're not going to go to court because of this.
Just a binding arbitration provision in a contract does not guarantee that you do not go to court. It is a mandatory arbitration provision. Yes.
Chris Sasha speaking again for really just asking a question here. As I read this, it says it's an option. Is this actually binding both parties to going into arbitration, or both parties have to agree to enter this arbitration process? It's also referring to a mediation process and related to him still being out.
If you look up on the screen, there's a list of applicable disputes. Under subsection A, which are optional, and under subsection B, which are mandatory.
It says must be done Article 2 of this rule, but I don't see an Article 2.
It should be on your RPT, just FYI. The general rules.
This is on the linked document as well.
Mr. Chairman, Chuck Burnett, ST20, could I speak for this?
Yes. Go ahead.
Refresh your screen.
Chuck.
The reason this is really not, if you're on the SREC, this is new. Jim has been working this, Jim Pickle, for a long time. I spent a lot of effort in this. This is to create problems that we've had. It's just to make it easier for us to avoid problems. Actually, we want it to avoid court, and so that's the reason for this. But we've been somewhat powerless in the time. But the county chairs and so on have come to us, have pleaded with us. Can you solve this problem, solve these issues with us? So this is an attempt to try to stay out of court and give us a little bit more authority if people will enter into the arbitration process to try to clean up problems and stuff. If you look again, I encourage you to look at A and B and look at what it says that's mandatory, what it says is optional, and look up the points. Look up and B where it says mandatory. Look at 1, 2, and 3 and actually see what it actually says. These are severe problems that need to be dealt with from time to time, and that's the purpose of this, is to deal with these issues. Some of y'all may not know, in the past, Montgomery County had 2 different people claiming to be county chair. I mean, there's all kinds of stuff out there, and this is to try to deal with these issues.
Chuck, time.
Mr. Chair, Daniel
Yes.
Hunt, SD3.
For or against?
Against.
Okay, good. Please proceed.
First, I want to say I think we do need an arbitration process, but I'm just not sure this is it. There's a lot in here that I'm confused by. Under how arbitration process is presented, Part B, any dispute pending in a court of law that otherwise qualifies for resolution under Article 2 of this rule. But there's nothing that's marked as Article 2 of this rule. So I don't know what it's referring to.
Thank you.
So and that's just one instance. So I'm confused by the way it's written, and I think there's some problems with it.
Mr. Chairman,
Yes. Who's this?
who's speaking? Mr. Chairman, Grant, this is seven, speaking in favor.
Time's up for in favor.
Okay, well, I'm still in favor.
We've hit the 5 minute.
Mr. Chairman,
Yes.
Dave Wilson, SD 11, I'd like to offer an amendment.
Okay. Please proceed.
I would like to, under the applicable disputes, A2, I would like to strike that one.
Okay. He wants
The second I'll speak to.
to. Any dispute as to an interpretation of a county party rule or bylaw.
Correct.
That's optional. Is there a second?
Second.
The amendment to the amendment's been seconded. Any debate on?
I'd like to speak to my amendment.
Go ahead.
Okay, the reason that I've offered this up as an amendment is because with regards to county rules and bylaws, we have uh, methods in place by which we have a parliamentarian to make judgments there. We have chairman that can make a ruling. We have a body that can overrule the chairman. So we have things in place to deal with those issues. We don't need arbitration from the SREC. Thank you, Mr. Chairman.
Thank you. Anyone else on? Keep your remarks contained on the amendment to the amendment, which is that striking of subsection 2.
SDA speaking against the amendment to the amendment. So I think maybe there's a misunderstanding here. This again, it's an alternative to court, right? So if say there was a dispute about a county party rule or bylaw that couldn't be resolved internally, right, through the methods that the author of the amendment described, then I mean the last resort is court. So we're not saying that you bypass internal remedies that are there, right? Like the parliamentarian giving advice, not the parliamentarian, why can't the party advise chair? The chair rules certainly, the chair is still wrong. I mean, there could be an appeal with ends up, just being wrong. So again, this is the final method to resolve. That's an alternative to going to court. That's what the intent of this says, not to foreclose the other parliamentary procedures that are available.
Thank you. Anyone else on the amendment to the amendment, Craig?
Mr. Chairman, parliamentary inquiry.
Yes.
Can we,
Wait,
you read?
hold on one second. Are you speaking for or against the amendment to the amendment?
The amendment is the entire,
No, just the striking of subsection 2.
I'm sorry.
Okay. Go ahead, Chris.
Just for clarity, because it's no longer on the screen, can you read the language that is being struck?
Any dispute as to the interpretation of a county party rule or a bylaw.
Thank you, Mr. Chairman.
Anyone else? Seeing none, we will vote on the amendment to the amendment, and that's to strike the language I just read. All in favor of the amendment to the amendment, not the entire Rule 47, please say aye.
Aye.
All opposed?
No.
Can the ayes stand up, please?
Start yelling.
Please sit down. The nays stand up. Thank you. The nays have it. The motion fails. Sorry, Josh is really loud and he's like sitting next to me, so it totally outweighs what I can hear. Okay. Now we are on to the main motion. We currently, everybody who's speaking for is out. We have 2 minutes of time that have elapsed on the speaking against. Craig, did you want to speak?
speak against.
Okay, go ahead.
Craig Liccardi, SD1. There's a number of defects in this entire rule. It conflicts with state law. Courts are given the jurisdiction over certain areas based on statute, and we can't, as a party, necessarily overrule state law. I mean, that's kind of a known thing. By saying that courts have no further jurisdiction, again, we can't countermand state law. Arbitration, by its nature, is supposed to be, the arbiters are supposed to be neutral third parties, and so by having our own party members be the arbiters inside the party. It's not a neutral third party. So that in and of itself is a problem. And when the members of the arbitration team are chosen by the chair, then you have kind of another um, thumb on the scale, so to speak, possibility. And so okay with the idea of arbitration to solve intra-party issues and conflicts and problems because there's a number of them all over the state that we've all could probably talk for hours about different counties where there's problems. But an arbitration needs to be done, it needs to be worded and been properly put in to where arbitration is going to be effective and neutral for those who are going to be making the final binding decisions. And this rule does not accomplish that at all.
Point of information.
Yes, please state your point of information.
Dan Biggins, SC 28. I'm still, the only profession I honestly never wanted to be was a lawyer. So I'm trying not to say anything bad about lawyers, but what I'm trying to understand all of this, I need guidance. What he said, I need guidance from the ones who propose this, lawyer wise, legal wise, whether this will suffice in arbitration. Even the chair could make his own judgment. That would be nice to understand that.
Was that a question?
Yes, I would like your opinion on this.
Just inflect your voice up at the end so I know. Um, no, the chair's not advised. However, we counted your time as against.
Mr. Chairman, Brandon Moore, SD 21.
Yes, Brendan.
Against then a point of information, just in general against because this is massive change. It's very significant, and honestly, I don't think that I am prepared to cast a knowledgeable vote on this. And then secondly, for the point of information, in the section titled "The Mechanisms for Resolution," is the chair advised, and because we cautioned earlier about making any changes to this, I may have an amendment proposed, very minor, but is the chair advised where it says in that second line, will meet in person or via Zoom? Is there any specific reason perhaps that Zoom is specified rather than via electronic means?
The chair's not advised as to whether or not as to the reasons why Zoom is specified in, but I would probably just proceed to a vote would be
Okay.
the feeling I'm getting.
Mr. Chairman, point of information,
Yes.
Melinda Morris, SD 13. I remember when you were chair, you resolved several disputes. So how is this different from what you did
Th- th-
years ago?
This is a binding arbitration provision as opposed to the informal dispute resolution that a chair does on a regular basis.
So do we need a binding arbitration versus what the chair's been doing in the past to settle
That's up to you
disputes?
guys to decide right now in voting.
I have one more question. Will the RPT be filing fees to provide arbitration?
We'll be
Be filing a fee to provide arbitration?
filing, I don't,
Charging a fee to provide this arbitration service?
the only thing provided is what's written in the proposed Rule 47, and I don't believe a fee is in there.
Mr. Chairman,
Yes.
Chris Sasha, SD 14, speak against.
Do you have any left? 45 seconds.
Mr. Chairman,
I'll be
we
brief.
have time for one more.
Go ahead.
I understand the need for dispute resolution in a quick manner. I conceptually like the idea of looking at arbitration. I don't see how, I just feel like this is undercooked, or just haven't been briefed enough, so I'm going to be voting against this.
Done. 18 seconds.
I just plead with everybody, reject the desire or the temptation to go with the top-down solution. These are tough things. I went through it. Everyone brings up Montgomery County. I was there. But let's think about what you're doing. And the SREC doesn't always have time for this.
Thank you. We'll proceed to a vote. All in favor of the proposed Rule 47 amendment, please indicate by saying aye.
Aye.
All opposed?
No.
The noes have it, the motion fails. If there's no objection, we'll now move on to Rule 45 is intentionally blank. So if there's no objection, we'll move through Rule 45 to Rule 43A, Platform and Principles. Are there any amendments to Rule 43A?
Mr. Chairman, Andy Eller, SD 24.
Go ahead.
I do have an amendment. I believe the secretary has it.
Let me get ahead of time too. I just want to say, raise your hand if you have an amendment to 43A specifically. So we got 1, 2, 3, 4, 5.
Well, I mean, my amendment's presented on the screen.
So Andy's, what? No,
Yeah.
it's not.
Maybe seeing this
Okay.
thing.
So we got 5 to 43A. Okay, Andy, go ahead.
Okay. This, I got to find it on my stuff too. This basically refers back to what Leslie and Jerry Fisher were talking about. In order to allow the Legislative Priorities Committee to have some type of authority to advocate for some of our core principles that are contained in the platform and principles, platform preamble and principles, I'd like to add this statement to 43A just at the very end. It's a very simple, quick statement so that when something comes up that violates our core principles or the preamble, the Legislative Priority Committee can take action on that and actually advocate for or against something.
Is there a second?
Second by Chuck.
I'll second.
Second by Melinda Morris. Andy,
13.
Andy, do you want to present any more?
No, I think I said it all.
Anyone else speaking for or against?
Mr. Chairman, Becky Green, SD 17.
Yep.
I served on a subcommittee of
For or against?
I'm for. I served on a subcommittee of legislative priorities this past 89th session on the Medical Freedom Subcommittee. And I was involved in all the meetings. And I will tell you that with 10,000 bills that are filed during legislative session, things come up that we're not anticipating. And when we have only 8 legislative priorities, and those are what we've been mandated by convention to pursue, we sometimes need to sidestep and look at something that is core to our Republican principles and beliefs. Maybe like a pro-life bill comes up, something like just concerning the abortion pill. Well, if pro-life issues are not one of our current legislative priorities, it really ties our hands because we take those legislative priorities parameters very seriously. And the first thing we ask ourselves is this one of the legislative priorities mandated by the convention? So if we have a little bit more leeway to pick up something like Second Amendment gun rights or a pro-life issue that may pop up during the legislative session, it frees legislative priorities to pursue and promote our Republican ideals in that area and doesn't tie our hands so much if we add this language.
Thank you. Anyone else? And by the way, I want to remind everybody, there's a sign-up sheet on the front if you're here to testify at 3 p.m.
Mr. Chairman,
Yes.
point of information, do you know the original intent of the legislative priorities? Original intent.
The original intent of the legislative
Creating
priorities.
legislative priorities. The reg- Let me rephrase the question. Are you advised that the original intent of the legislative priorities was that before we had them, that on behalf of the Republican Party of Texas, SREC members were prohibited from testifying as SREC members? And what legislative priorities did was give them that by direction of the convention.
Thanks for the leading question. Yes.
Mr. Chairman, point of information, but Westbrook SD19. Pardon my ignorance, but which legislative priorities committee is this talking about?
The Legislative Priorities Committee of the State Republican Executive Committee.
Okay. Mr. Chairman, if required, I can amend that to put in the SREC, Legislative Priorities Committee.
I I don't know if that's needed, and when we go through the non-substantive editing, we're going to make sure that the defined terms are consistent. So I don't think that's necessary.
Okay, thank you.
Mr. Chairman,
Yes.
Matt Patrick, SC16. If I may, I just want to go through what the principles are that we're referring to so that people will understand what they're voting
I'll
for.
have you speaking in favor then. Go ahead.
Okay, so I'm just looking at the current platform. These are the principles, the laws of nature and nature's God. We support the strict adherence to the original language and intent of the Declaration of Independence and the Constitution of the United States and Texas. 2, the sanctity of innocent human life created in the image of God, which should be equally protected from fertilization to natural death. 3, preserve individual Texan and American sovereignty and freedom. 4, limiting government power to those items enumerated in the U.S. and Texas constitutions. 5, personal accountability and responsibility. 6, self-sufficient families founded on the traditional marriage of a natural man and a natural woman. 7, having an educated population with parents having the freedom of choice for the education of their children. 8, the inalienable rights of all people to defend themselves and their property. 9, the free enterprise society unencumbered by government interference or subsidies. And 10, honoring all of those that serve to protect our freedom. I'm going to suggest that those are so broad and expansive that this would make give legislative priorities committee the ability to opine and on almost innumerable number of bills in the legislature.
Thank you. Anyone
Mr.
else?
Chairman?
Mr.
Mr. Chairman,
Harmon?
oh,
Go ahead.
Armin Calderon, SD27. I'm not completely against this, but I'm going to speak against it.
You're against.
To me, legislative priorities are legislative priorities. And a big reason to do that is to make sure we get those priorities done and we focus on them. 8 priorities. Matt just listed 10 others. So now we just more than doubled what the committee is going to focus on. Plus, they're very broad, so it could be even more. I really think the legislative priorities need to focus on the legislative priorities that were passed at convention. Now, all those other issues, I think, as the entire Republican Party, and since there are principles, we should be advocating for them nonstop as a whole party. But the Legislative Priorities Committee needs to be focused on the legislative priorities. Thank you.
Thank you.
Mr. Chairman,
We're here. Chris?
I'm going to speak against, not on the principle, but on function. Nowhere in these rules are contained anything about how the Legislative Priorities Committee of the SREC shall function. That is contained in the rules for the SREC. I just don't think it doesn't even match with this rule. In fact, I would like to raise a point of order. This is not germane to platform and principles because it's directing a committee of the SREC.
Okay, there's been a point of order raised. Andy.
So if they want. Who is it? Andy Eller.
Thank you. Uh, the point of order has been raised as to the germaneness of the amendment. The point of order is well taken and is sustained, as Andy admittedly suspected. Thanks, Andy.
You didn't have to say that.
I'm shielding myself here.
Well, sometimes you just have to take a shot before
Yeah.
somebody tries to call it out of order.
You're good.
Chairman, can I make a comment for the amendment? Is it out of order?
Does? I tell you what, Melinda, can you get together with Gene? Because I think he has the same motion and have one of you. What? Oh. 143. Okay. So I think you have the same motion as we just considered.
No,
Okay.
no. I'm
Go,
not considering Andy's motion.
go ahead and propose yours.
I wanted to give some clarification as to the need for this.
Can you propose your language and make the motion, and then I'll give you a chance to lay it out.
Okay.
Do you have the language?
Well, I guess this is just a point of clarification regarding this amendment.
There's no amendment. We have an amendment which is exactly the same as the amendment we just considered.
Yeah, and that's the same amendment that I proposed, was what's up on the
Right.
screen.
You have an additional amendment other than that?
I do not have an additional amendment to
Okay.
the amendment. I was just gonna make
No.
a point of clarification.
Well, the
Out of order.
yeah, well, the amendment was out of order, so we're now not on consideration of that amendment. We have, who else? Gene has one? Okay. Gene,
Um, yes, I sent the text to Rachel,
we're bringing it up.
um, and I'll just make comment that, describing at this point what the platform committee does is inappropriate. It should be in Rule 34D, I think. And my proposal, and I move to amend 43A to read the delegates of each biennial state convention shall approve the list of principles. In my opinion, those principles are the foundation for everything else in the platform.
Is there a second?
I'll second.
A second by Melinda. Gene, do you want to speak to this?
Okay, I don't think I can expound too much on what I just said. I believe that we are establishing those principles as the basis that we would like to hold elected officials to support, and stating how those are produced by the platform committee doing something is nice, but I think it should be established that the convention itself, the delegates, are the ones that establish it.
Anyone else?
I'll make a comment for this, where I can include my explanation. Um, this past legislative priorities session, we had our 8 priorities, and abolish abortion was not part of the 8 priorities. So people were actually contacting me stating, does the Republican Party, are they not against abortion anymore because it's not listed in the 8 priorities? So, for the general voting public, they're thinking that just the 8 priorities we come up with is what the Republican Party is standing for and supporting, and they're forgetting about our platform, our preamble, our principles are also what we stand for. So we're trying to kind of find a way where we can link things together. Abolish abortion and the right to carry are like permanent priorities and are core principles. When all the focus is just on legislative priorities, they kind of forget about our core principles in the platform. So we're trying to find a way to just kind of link these two things together.
Chairman,
We are,
SC 16.
Jocelyn ST15, speaking against. Um, I- we have a list. We have a committee to create the list. If we just allow the delegates to do it, then there would be no list. And how would we prepare that? How would we prepare a list for people, the delegates to approve?
Mr. Chairman, Matt Patrick, ST 16.
go ahead.
Yeah, I'm speaking against I mean, as chairman of I was on the platform for 4 different times and chaired at the last 2 conventions. And this is the very fundamental job of what the platform committee does. And remember, we're setting out in these rules, here's our major committees and here's the job that we're giving to them. So we've created the committee, and the platform committee reviews and comes up with the principles and the platform planks, and we reshape that every single convention. Um, Historically, we haven't really changed the principles much. It's very rare for us to change the principles. So because the people on platform and the platform committee leaders have thought that we should not disturb that too much, that our principles should be fairly consistent. And as Mr. Flynn says, if you take this out of the hand of the committee, there's no one to make that list. And I think that we would end up having a shifting set of principles, which I don't think is good for the party. I will say, just as an amendment, I actually have requested the platform committee to add an 11th principle this cycle, which I hope gets passed, which simply says that anyone who's elected or runs as a Republican must follow the rules of the Republican Party of Texas in an effort to give something firm for censure that ties, because it's the principles that we look to. And so those things should be consistent for censure. And so this ties the ability to censure back to our rules.
Keep on the,
So the
keep on
things
the
we put
amendment.
in here will be consistent. So I'm against this because we have to have a steady hand on the principles, and that has to go through the platform committee.
Mr. Chairman, parliamentary inquiry.
Please state your inquiry.
Is the platform committee report amendable on the floor? Is this list amendable on the floor?
It's my understanding that it is, yes.
All right. Thank you, Mr. Chairman.
Chris Bird, Mr. Chairman, SD 25. I have a point of inquiry.
Go ahead, Chris.
Thank you, Mr. Chairman. As written, I'm not certain about how workable this is, kind of drawing back to the comments of Mr. Patrick, where I did serve in the 2022 on that resolutions committee. Having said that, I am curious if what is really the intent here is that in practice, the platform committee spends all the time, works through all the issues, and presents the principles of the party, which have by and large remained untouched for quite a while. And then the delegates approve them. But as it is right now, as written, I don't know how this would be even workable. So that's my inquiry. How is it workable, and what is the real intent here?
The chair can't speak to the intent, but the existing rule not amended by this provides that the committee comes up with a list, which are then voted on by the delegates and approved when you get your sheet at the end.
That's why I asked. Are we?
Point of
Mr.
order.
Chairman.
Go ahead.
Dan Biggins, SD 28. I call the question on this.
Dan Pickens called the question. All in favor of calling the question, please say aye.
Aye.
All opposed?
Nay.
The ayes have it. The motion passes. No, the The motion to call the question passes. We are now on the amendment. So all those in favor of the amendment, please say aye.
Aye.
All opposed? The noes have it, the motion fails. I believe we are all done with Rule 43A. We'll move on to Rule 43. If there's no objection, hearing none, we are now on Rule 43.
Mr. Chairman, I have an amendment. Pull that up on.
We have an amendment. 43. Does that accurately state your amendment? Sorry, it does not.
Yeah, I got it.
So-
No, it does not. I have it marked.
I'm looking at it on our computer and it does.
This is not a rewrite or anything like that. Where I'm changing.
Hold on, I'll let you present it. Let me get it up on the board and make sure the text is right. Bear with us a second. Okay. Does that accurately
Yes,
state your
that
amendment?
does. Yes.
Okay, is there a second?
Second.
Was that? Yep, Susan. Okay, Mr. Chairman.
Yeah, this is not a rewrite or anything to that effect. What this does is requires candidates change some wording is changed just to require the candidates to actually fill it in and complete it, I should say, and require the county chair or the CEC to actually put it out on the website. That's it. It takes away the part down there that at the discretion of the executive committee to not post or to not make public, and it actually adds to the rule should not apply to judicial and law enforcement candidates, so they won't have to. Some of them may have some issues with wanting to be perceived as neutral, given the fact that they're in a judicial or law enforcement race, but others will be required to actually fill out the form, and the county party will be required to post it on their website.
Got it. Thank you. Anyone else for or against? Dan?
Daniel Hood, SD3, speaking in favor. I think the addition of law enforcement is a good move. As was mentioned, law enforcement often find themselves in situations where they need to be following the law, not be following our platform. Just like I agree, it's the same as a judicial candidate. There's nothing that requires law enforcement to recuse themselves like a judicial candidate or officer, but there is a similar need for neutrality. So I think this is a good move, and also I think it's the county chairs definitely should be publishing this information, getting that information out to the public.
Thank you. Anyone else?
Mr. Chairman, Brandon Moore, SD21. I have what I hope is a friendly amendment.
Go ahead.
In the second line, second sentence of Rule 43, where it reads, the county or state chairman shall, and then from that point, strike distribute either an electronic or a paper copy.
Wait, where?
Second sentence, leave the county or state chairman shall, but strike
third line.
distribute either an electronic or a paper copy, and replace that with make available. Actually, leave copy, make available a copy. And if there's a second, I'll speak to why I'm saying this.
You can ask him if he wants to accept it as a friendly amendment. If it's not, I don't think it's changed. You can propose it after we're done taking this up.
I think your idea is to make it blanket, just provide the information itself.
No, it's just to make it available rather than providing it.
Okay. I can, yeah, I'm okay with that.
Okay.
Sure. Mr. Chairman, Andy Eller.
Yeah.
SD24, point of inquiry.
Please state your inquiry.
Um, what would happen if, in this instance, a candidate chose not to respond? What happens?
Go back.
Gotta get this first.
Presumably their response would not be published, or it would be published that they have not responded.
That is correct. That's my thought process.
Thank you. Anyone else?
Mr. Chairman, point of parliamentary inquiry. SD8.
State your
Raymond
inquiry.
Troy. So as far as germaneness goes, is anything about Rule 43 germane, or should we wait till this?
No, and to be honest, the friendly amendment probably wasn't germane, but I let them do it as a friendly amendment because better than spending another 10 minutes debating it, to be honest.
Sure. So if we want something to rule, if we want to amend something in Rule 43 that's not one of these red lines, we just wait till this is done first.
Yeah, we're gonna still be on Rule 43.
Okay. Yeah, I'd like to offer a friendly amendment, actually, or what I hope is friendly.
State your friendly amendment.
Okay, so where it says shall be collected and recorded by the filing entity and will be published on the filing entity's website, I don't think you need the word will there. You can just say shall be collected and recorded by the filing entity and be published on the filing entity's website. Right, the shall applies to
Be collected and recorded by the filing entity
and published, yeah. So the shall applies to the whole thing.
it's a grammatical. Candidates' responses shall be collected and recorded by the filing entity, and actually, I should probably just say published on the filing entity's website prior to the primary. So would crossing out will be correct?
Yeah, given the fact that it does tie to the shall.
Yeah, it's tied to the shall. So
Shall,
shall
right,
be
because it
collected
shall be
and
collected
recorded
and
by the file.
published. Okay, I'm comfortable with that.
Actually,
Because it shall
should
be
be
collected
shall be collected and recorded by the filing entity and published on the filing entity's website prior to the primary.
So it kind of ties together. So that's fine.
Okay, it's accepted. All right. Anything else? We're going to move to
I have a quick question for the author. What is your intent for a county that doesn't have a website?
It says it down there. If they don't have a website, then they can, or should I say, that it will be made available at their offices.
Very good. Thank you.
Yep.
Mr. Chairman, Brandon Moore, SD 21.
Yep.
As I'm reading through this, and I like it,
or against
everything about it, just Rule 43, the proposed amendments to it. I like
or
everything.
against it.
Against.
Yeah.
I like everything about it, but I have one concern, and that is when we say that the county parties will publish it on their website if they maintain a website. We have a lot of counties that may have a very, very basic website and they don't post candidate filings on their website like the state party does. We already have a lot of county chairs that are just volunteers and not able to really do that adequately. I like the intent, but I think we need to make it an optional that they can put it on the website or provide a copy.
Now, if you want to offer a friendly amendment that says down here where it says the filing entity has no website or limited website availability, a copy of the response can. But
yes, let's do that.
Okay, I can accept that friendly amendment.
Okay.
But where you
So-
had it, it seemed like you were trying to exit out
Okay.
together. So
Hold on. So friendly amendments proposed been accepted by the author.
down there.
We got to get the language.
Yeah, if the filing entity has no website or limited website availability, a copy of.
Yes.
Which line is it?
Them, but the fact that they still have to give it out.
Filing entity has no website. So it's the fourth line up from the bottom, 2 words in, after the word website. 4 lines up from the bottom on the left.
Right.
After the word website or limited website availability. Is that the wording?
Yep. Is that good with you?
Yes.
Okay.
Yep. Now I'm in favor.
Okay. Thank you. we have anything else? Seeing none, we are going to move to vote on the amendment. All in favor, please say aye.
Aye.
All opposed?
Stan. Stan.
I can't figure out who got more because everybody was so unenthusiastic. So everybody in favor, please stand. No, this is on the motion, on the whole thing. Yeah.
Website.
It shall. They gotta do it, no matter what. Yeah, stand up. Stand up. One or less enthusiastic. Huh? One or less enthusiastic. No matter what.
Everybody.
I don't know what the problem is trying to solve.
We got it.
Solution.
Okay, stand up, stand. I mean, sit down. Sorry. Stand up if you vote no. Okay, please be seated. The ayes have it. The motion passes unenthusiastically. I'm just kidding, Greg. Okay, still on Rule 43. Any other motions, Rohit?
I'd like to make a motion.
Rohit, and then we'll go Brenda after.
All right. So where it says prior to the primary, I would strike out the words prior to the primary and replace it within 10 days of the close of candidate filing.
What do we have?
Line.
What? Give us a line.
So okay.
Line up.
Right. Yeah.
The filing entity's website and then striking out prior to the primary and putting in.
Within 10 days of the close of candidate filing.
Where do you want it and what language do you want?
That's what I said. So where it says
On the
prior to the
filing
primary,
entity's website,
strike
cross out,
that.
strike prior to the primary.
Okay, and then replace with within 10 days of the close of candidate filing. Yep, so that's what I'm proposing. The reason is that, yeah, prior to the primary.
Hold on. Second, do we have a second? Second by Ms. Jackson. Go ahead, Rohit. You can speak to your motion.
Yeah, so the reason I'm proposing this is if you say prior to the primary, that could be one day before the primary. I mean, if there's some reason why, say, a county chair or a state chair wants to hide a candidate's responses, I mean, you could do that by just waiting until the last possible day to comply, which would be under the current language, one day before primary election day. So this actually sets a deadline that ensures people will have it in a timely manner.
Okay, anyone else? Seeing none.
Mr. Chairman?
Yeah.
Daniel at SD3. This might be a friendly amendment, but I would move within 10 days that clause to will be published within 10 days on the website. And my thought is then it would include having paper copies available if they have limited or no website.
So what is the
Move within 10 days of the close of candidate filing.
Okay.
To after the word filing entity and will be published or may wait, what does it say?
No, just in published.
I can't tell what's crossed out and what's on there now.
In published within 10 days of the close of candidate filing on the filing entities.
Correct. Yes.
Right.
Yeah.
Except friendly amendment.
Yes.
Okay.
Point of information, Mr. Chair. Is anybody seeing the updates on your computer? I refreshed about 5 times. I'm not getting any of the updates that are on the screen on here.
The answer to your question is yes, they are getting updates, but no, not to this because this isn't on there. This is up on the board.
This is on.
Looks like
Okay. Now closing discussion and voting on the motion. All in favor of the amendment, and that's just to add published within 10 days of the close of candidate filing and striking prior to the primary. All in favor, say aye.
Aye.
All opposed? The ayes have it. The motion passes. Anything else on Rule 43?
Yes, sir. Chairman, I'd like to
Yes.
make a motion, please. I'd like to amend Rule 43. I'd like to replace the two instances of the word request with the word require, and replace the first instance of the word should with the word must to read as, comma.
Thank you. So it's request with require.
And should will be must.
That's what this says. What does it say right there? Okay. Get rid of must. Hang on, let's look. General.
Right.
I'll show you. There it is.
Okay, so is it just those two instances?
Yes, sir.
Two instances of request to require. Is there a second? Second by Greg. Do you want to speak to your motion, Brenda?
Yes, I believe that the amending Rule 43 for the purpose of promoting more of a commitment from GOP candidates and representatives to support our platform and pass our legislative priorities once elected, as well as providing more grounds for censuring them if they don't, is necessary. I believe amending Rule 43 to get the words request changed to require, replacing the word should with must, as well as removing the next to the last sentence of Rule 43 entirely will help accomplish this.
Mr. Chairman, I'd like to speak against.
No.
Yes. Hold on one second.
All of this is an interest.
Brenda.
Yes.
Hold on. Are you done yet with your presentation or no?
No, I wasn't. Sorry.
Okay.
All of this is in the interest.
Can you confine your remarks to the proposed amendment, which is two instances of require? You've been talking about the changes at the end that have already adopted. Thank you. Keep on. You can
I
proceed.
need to go ahead and strike that then, the last sentence. Let's see.
Wait, just speak to your motion. There's a motion on the floor.
All of this is in the interest of promoting more of a commitment from our GOP candidates and elected representatives to support our platform and legislative priorities, even though changing the request of Rule 43 to requirements may not technically be enforceable per the TEC. The word require is the rule, in the rule refers to a requirement. If a candidate refused to submit to the Rule 43 requirements of making written commitments to the GOP platform and our legislative priorities, that in itself would be construed as a tell as to their level of commitment to support, promote, and push them into the legislature. They would be on record for having refused to submit to the Rule 43 requirements, and once published would be signaling to the RPT voter base and party that their level of commitment is questionable. And while lack of a candidate's written commitment may not provide grounds for future censuring, it would provide a great talking point for an opponent who would fulfill the required 43 commitment to our legislative priorities. Even if it isn't 100% effective, it is better than what we have now. We have to start somewhere.
Mr. Chairman, I'd like to speak against.
Yep, go ahead.
David Wilson, SD 11. I'm going to speak against this motion because with that language in there to where the county chairman shall require it, it insinuates that if a candidate does not do that, that the application can be rejected.
Thank you.
As a result, I'll be voting no.
Anyone else for or against?
Mr. Chairman?
Go ahead, Chris. And then
John,
who would, well, we'll go, Chris has a question, and then we'll go John Beckmeyer. But
Brenda, what's the expectation on how to enforce a candidate reading the platform? Are we expecting the county chair to watch them read the platform?
Thank you.
Brenda, do you want to respond or no?
My question, I'll bring it. What I'm asking is, you're saying
We-
the county chair shall
Chris.
require.
We got the question. Okay, go ahead. What it is against?
All right. Final. This says the county chair shall require each candidate to read the party platform. Whereas versus requesting at least says like, hey, would you please read it or have you read it? Are we taking them at their word? Or are we requiring the county chair to sit there and observe them reading the platform? That's what I'm asking on this. Like, how is that an enforceable mechanism?
I guess it's not enforceable.
Go ahead, Brenda.
But the fact that we are asking them, we're requiring it, then it shows them that we're serious, right? So it's an onus on them to read it.
Okay, John.
Mr. Chairman, leading point of information, are you advised that whenever we first put this in, we require it due to a legal opinion that we received at that time, that we would find ourselves not only in court, but in violation of TEC law? Say yes.
The chair's not advised, but has heard some from the former executive director of Texas GOP. Anyone else for or against?
Josh Flynn, SC 15. What we just heard from the proposer of this was that we should require, but we can't require them to actually do it. We have to take them on faith. If we don't have an enforcement mechanism, then our rules really don't mean anything. We're just writing things out that we wish that people would do. And this is one of those.
I speak in favor of it. I think it lends itself towards transparency. It lends itself towards the responsibility of candidates to let us know, let the voter know where they stand, and I think it's incumbent upon us to take it as strong as possible to keep malefactors out, so to speak.
You, anyone else for or against?
S19 David Sprague against.
David.
I'm against this because this is the exact opposite of being serious. We're passing a rule we can't enforce and have no way to enforce. And it shows we are not serious about our rules because we are willing to create rules we cannot enforce. No change like this should ever be made to a rule that we can't enforce.
Thank you. Anyone else? Seeing none, we'll move to vote. All in favor of the amendment, which is to add the two requires, please say aye.
Aye.
All opposed?
Nay.
The nays have it. The motion fails. Do we have anything else on Rule 43?
Yes, Mr. Chairman.
Okay, raise your hand if you got something on Rule 43. So we got two more left or three? Melinda, you got one? All have been submitted to the secretary?
I have not. Mine's a response to, or another alternative to what Brenda just.
I haven't. I
Okay.
can email it in.
Melinda, did you submit yours? If it's simple, we could just take it up.
I think mine is simple. Yeah.
Rohit, go first.
Okay, so it's going to be right before the last sentence, so you can go to the place, the rule. I'm telling you where it is first, so then I'll read. Yeah.
Right?
Where the cursor is.
Yes. Okay. So my proposal is if a candidate fails to
That's what I've got.
respond, the such refusal shall be noted by the filing entity. Well, like, noted like on the website or in the files if there's no website. To answer your question, yeah. So yeah, I mean, essentially what this says is to say that yes, we can't force the candidate to respond. We still have to accept. Oh, sorry.
Is there a second?
Dave Wilson, ST11, I second.
Go ahead. Keep going, Rohit.
So yeah, the purpose of this is I understand that we can't require the candidate to do it and say that we won't accept their application if they don't, but at least we should put some teeth in it. Like, okay, if they don't respond, I mean that should be explicitly stated they didn't respond, they refused. So, I mean, it's an intermediate step versus rejecting their application.
Thank you. Anyone else?
Mr. Chairman, may
Go ahead,
I
Craig.
make a friendly amendment
Sure. Go ahead.
just to perfect the wording a little bit? So if we could reword, that was my,
Did
what I
this
was
take
gonna,
care of your suggestion as
yes,
well?
this would be
Okay.
mine. The wording that I would suggest, or that I would put forward as a friendly amendment, if the candidate fails to timely return the completed review, comma, the filing entity shall prominently publish on its website. I'm sorry, I went too fast. Go ahead. The filing entity shall prominently publish on its website as applicable, comma, as applicable, comma.
Would
A
it be
note.
a review, completed review, or responses?
It's it's a platform and legislative priorities review containing the candidate's responses.
Okay.
Should that be response or should it be review? It's
No. Hold on.
Point of order.
I think it would be
response is fine.
I think it would be responses.
That's fine.
Got a point of order?
Forget
Point
it.
of order over here. Carmen Calderon, SD
I
27.
haven't finished.
Oh.
I'm
I feel
almost
like
done.
we're getting.
Hold on, there's a point of
Where we
order.
stop.
Supersedes.
As
I feel like we're
applicable.
getting too lenient with these friendly amendments. I mean, an amendment was put on the floor, seconded. Now it's the bodies, and now we're just completely rewriting it and changing it. I, I don't think that's real Robert's Rules of Order that are being obtained here.
Don't our committee rule allow it though, or?
The amendment hasn't been proposed and seconded yet. So if you could
Sorry, I
read,
thought it was seconded.
okay, if you can let him type it up there, and then if you can remake that point of order, that would be great.
Okay.
That'd be great.
Let me get it. If the candidate fails to timely return the completed response, comma, the filing entity should prominently publish on its website, comma, as applicable, comma, a notice that the candidate not submit the complete response.
Okay. Is
So, yeah.
hold on. Is this acceptable to the author?
It's acceptable.
Okay. You make a point of order. Okay. Let me just respond to that. I do think your comment is well taken, and to the extent you make a point of order, we will enforce that. I think this applies and is germane because it's explaining what noting is. It's also clarifying what failure to respond is. Okay. Anyone else for or against? Seeing none, we'll move to a vote. That's on the underlying language, second sentence from the bottom. All in favor, please say aye.
Aye.
Opposed? The ayes have it. The motion passes.
Mr. Chairman,
Yes, go ahead.
I have one final sentence we can add at the bottom. Very easy. Easy peasy. Failure of the state, the county or state chairman to display the candidates' responses should be considered a centrable item. No candidate responses to anything have ever been displayed in Harris County. So we can make these rules, but the county chairs aren't going to do it.
Does that accurately reflect your amendment?
Tarring and feathering.
Thumb screws, the water torture, and censure.
And perpetually labeled it.
We're not going to do your actual language.
Hold on, let's get the language up. Then it was David that brought up the point of order. Or David, was that you?
Not your name.
Okay, hold on. Let me get it up there. Shall be what?
Hard and feather.
Shall be considered a centrable item.
Okay.
Failure.
Central, just put central. Does that accurately reflect your amendment?
Yes, yes, sir.
Mr. Chairman, Daniel Hunt.
Is there a second?
Oh, I'll second, but I also have a friendly amendment.
Daniel, second, and I believe David has a point of order. David, please state your point of order.
This is out of, it is not
Germane to, well, the motion is what the rule says. Point of order is well taken and sustained. It is not germane to Rule 43. Anything else for Rule 43?
44.
Okay. If there isn't any objection, we'll move on to Rule 42. Now, just so you guys know, we have public testimony. Sign-up sheet is in the front if you want to testify. Public testimony between 3 and 4. It's 2:24 now. We'll begin taking up Rule 42. I'd like to do a break somewhere between 2:45 and 2:50, and then come back for the 3 o'clock testimony. So just so you have an idea as to where we're going. Amendment to Rule 42.
Chairman Daniel Hunt, 83.
Go ahead.
I had heard this earlier as proposed Rule 8S, but actually it's fit better in 42.
Okay.
Any individual who is a compensated employee of the Republican Party of Texas or its partners or affiliates may not serve as an SREC committee man or committee woman or a county chair. I had actually emails to Rachel that was titled yes at the time.
Is there a second?
Second. I'll second. And
Second by
Rachel, you have
Craig Liccardi.
my copies I sent in to you as well for this.
Daniel, do you want to speak to your rule or to your motion? Sorry.
Well, I had spoken earlier. I'll say the same thing again. It basically would hopefully prevent conflicts of interest where people who would be able to even, possibly even vote on their own compensation. So I think that's something we need to consider. And then county chair could, there are county, I'm married to county chair being there, but I think maybe it ought to be because county chairs may do something that would affect the state party. I don't know. I'm not really sure about the county chair being in there, but
Chairman, let me. Yeah, I would. I think there's going to be a point of order on county chair because we'd have to.
Going to make a motion.
Yes, that's true.
Um,
County chair is not germane.
you want to make a motion?
I'd like to make a motion to amend the amendment by striking the word county chair.
There's a
I'll take that as friendly amendment.
Takes a friendly amendment. Okay, perfect. Is there? You want to continue, or is there any further? Okay,
That's it.
anybody else for or against? Go ahead. Sorry. Anybody else? Seeing none. We're going to vote on the amendment. All in favor? Did you want to speak? Okay. All in favor of the motion, please say aye.
Aye.
All opposed? Motion passes. Anything else on Rule 42?
I had submitted my amendments in red, and it's coming up on my screen, but it's not coming up on the big screen. But all the amendments that I'd recommended.
How many did you have?
Well, but it's not red.
Because it's in the what is on the screen is what you want.
Can I read the amended parts that are?
Hold on.
Okay.
There it is.
Just how many separate amendments do you have? Are they all contained in one? Okay.
Yeah, it was all submitted as one.
Is additional supposed to be stricken out? Okay. Sorry to say. The word additional should not be stricken out. It doesn't appear in here.
How come it's not showing up on mine? Is it showing up on your laptop? No, it's not either.
It is. Because otherwise it's saying the current version reads a person must be a resident of the district he or she represents additional as indicated by his or her current. So additional doesn't appear. I would delete that.
I think she's in live docs anymore.
I have a point of information if somebody could explain this. What I
We're,
don't
we're
understand.
gonna Dan, we're gonna let her lay it out in a second. We just want to get the wording and then a second. Okay, with proof of permanent residency.
I think she has to save it to live doc to make it pop up on ours. She should have been edited at this because it's up. There's some stories for sure we were up there at the top. Show that. Right there. Beat to the amendment that I was made. Or what? I can't see what she's doing.
Okay. Is there a second? Yes.
Second.
Okay,
I'll
seconded
second
by Becky Green. Melinda, do you want to speak to your motion?
Yes. I've been in the SRC for 4 years, and over the last couple of years, especially the last year, I've just noticed a change in the SREC. And this has prompted me to add rules to Rule 42 because of what I've noticed, what I've heard, what I've seen. We have SREC members living at girlfriends' houses that are representing districts. That prompted me to say that an SREC member should at least show proof of living in their district they're representing for 6 months. We require that from precinct chairs. We should at least require that for SREC members. Requiring just a voter registration to confirm your address isn't always correct. We have SREC members that are staff members in state representative offices that are chairing committees, which is a conflict of interest. So that prompted me to say no member of the SREC may be an employee of any federal, state, or county office. No member of the SREC may be an employed lobbyist. I was also offered an additional amendment to consider employment history when we're filling out these forms that the SREC members now have to fill out. So for the third part of the review, discusses the form we have to fill out and what we have to reveal. And then all SREC members shall disclose employment by candidates for campaign management. Because an SRC member apparently was a campaign manager for a Green candidate in the November election. So if SRC members are going to be involved in managing candidates, then they need to be Republican candidates. So I don't want the SREC to become a place for grifters, a place where people get on the SREC so they can look for job opportunities. We're there to represent the grassroots, our districts. We're supposed to be supporting the Republican values. And these issues are bringing conflict of interest. And I think it's affecting the credibility of the SREC. These things are happening and we need to tighten things up. And that's my reasoning behind this.
Chairman,
Yes.
ST19 David Westbrook. Point of, I guess, inquiry or information. Is the chair informed on whether the second change where it talks about employee of any federal, state, or county office, Is that supposed to mean office or office holder?
The chair's not advised as to what it's supposed to mean.
I would then like to make a friendly amendment to add holder after office so that it is office holder instead of office, because otherwise we're prohibiting any SREC from working for any of those offices, it sounds like.
You can offer a friendly amendment, but we have to ask what the intent of it. Hold on. And a friendly amendment's been offered to change the word office to office holder. Melinda, do you accept the friendly amendment or no?
Which, I'm sorry, which line is this?
No, it's on the queue.
Yeah, the intent is to discourage government employees.
Okay. So you do not accept the friendly amendment?
No.
Okay. She does not.
Mr. Chair, I have a point of information
Please
for
state your point of information.
I mean, he's bringing up the same point I am. I want to understand from the author. I could be a stenographer. I could be the receptionist at XYZ office. All of this stuff. Now they're all excluded because they work in an office, a state office, a county office. That doesn't make sense. And there's no reason to do what he just recommended when the sentence right before it says no member of the SREC may hold an elective. So it was right above it. I would like to make an amendment unless the author is willing to remove the no member of the SREC may be an employee of the state, federal, state, or county office. I move to strike that portion as an amendment.
Second.
Okay. What was this one? Got it. Okay, there's a amendment proposed and seconded by Josh to eliminate the line, no member of the SREC may be an employee of any federal, state, or county office. Do you want to discuss your amendment, Dan?
If we're trying to keep elected officials, that's in the sentence already above it. We really don't want to exclude anybody that may work in a state, federal, or county office. They're all over the place. In my county alone, that's probably 5% of the vote. Do we want to exclude those from ever having a chance to run for the SREC? I don't believe so.
Thank
Well,
you. Any other discussion?
What if we said
Hold on.
political office?
Linda, are you speaking against?
I'm speaking against. What if we clarify it by saying political office? You know, if they work for vehicle registration office, that's not political. But if they're working for a particular representative in Austin, that's political.
Mr. Chairman,
Okay.
point of inquiry,
Hold-
point of information, Mr. Chairman, Andy Eller.
Andy, go ahead.
Doesn't the sentence after that, that red area, talk about those that are already employed by elected officials?
Which sentence?
It does.
All SREC candidates shall disclose to their respective caucuses prior to their election the source of, and if they're employed by an elected official, registered lobbyist. Doesn't it not say that?
Yes.
Yes.
Thank you. Anyone else for or against? This is the amendment to the amendment. No, we will now move to a vote. Discussion's closed. The amendment to the amendment is to strike from the amendment, no member of the SREC may be employed of a federal, state, or county office. In favor of the amendments to the amendment, striking the portion, please say aye. All opposed? The ayes have it. The motion passes. We're now on the main amendment.
Mr. Chairman, Andy Eller, SD 24 again.
Go ahead.
Point of inquiry.
Yes.
Are you advised on how we would find proof of permanent residency for a minimum of 6 months? How that would be done?
There's not advised.
That can be done.
An example would be an electric
Oh,
bill.
hold on. Do you want to speak to that?
Speak to that.
Go ahead.
An example would be an electric bill. I mean, to show proof of residency for 6 months, a water bill, an electric bill. Where do you reside? You know,
Point of inquiry.
you're not living at your girlfriend's house.
Thank you. Andy? Yeah.
Point of inquiry. Okay. So when would that proof be required?
Well, it says
There's not
that they,
advised. Melinda, do you want to speak to that?
it says that they need to provide information to their SD caucus when they're being considered a candidate for the SREC. This would be information that they would provide to the caucus, which would impact whether they got elected to the SREC or not.
Okay, thank you.
Thank you. Becky, did you have a point?
I do. I'd like to offer a friendly amendment.
Yes.
The last sentence in red, management of non-Republican candidates shall be considered cause for censure review. The cause for censure review is not really germane. And I think we need to change that sentence to management of non-Republican candidates shall not be allowed.
I'm agreeing with that amendment.
Can we make it just my grammatical? I do agree. I think there is I think there is a germaneness problem with just that statement, but I think you can accomplish the intent with uh, SR no SREC member may manage a non or SREC members may not manage non-Republican candidates for office.
Mr. Chairman.
Is that acceptable as a friendly amendment? Becky, is that acceptable?
Yes, Mr. Chair.
Request for information.
Yes, please state your request for information.
What about, how does this affect anybody that might be involved with the nonpartisan office? Like that's a non-Republican candidate.
Would you like to offer a friendly amendment stating, adding the phrase in partisan races after the word office?
Sure.
Okay, do you accept that friendly amendment, Melinda?
No, I don't, because as I say in Harris County, there are no nonpartisan races.
Well, there are nonpartisan city races,
Well,
school boards.
yeah, theoretically. All right, I can accept it if we want to believe there really are some nonpartisan offices, but they're not. There's no
I agree.
in Harris County.
I agree with your sentiment, but technically there are, and it keeps it unambiguous.
All right, I can accept that as a friendly amendment.
Thank you. Any more for or against the proposed amendment? Seeing, oh,
Yeah, actually, I'd like to offer a friendly amendment, which says all SRC members shall disclose employment.
hold on before you. Let's get that language in there. Okay.
It's not a Republican candidate seeking office in a
Partisan election, in a partisan election.
partisan.
Are we good?
Not managed
There you go.
in a partisan. Okay, Gene.
Okay, I would offer a friendly amendment to add between disclose employment the words their history of. So it says all SREC members shall disclose their history of employment by candidates for campaign management.
And I'd say going back 5 years. Qualify
No.
by 5 years.
No.
5 years.
Hold on. The proposed friendly amendment was shall all SREC members shall disclose
Their history of.
the history of employment by candidates. Would that be office?
I think they have to qualify for the 5-year history.
Campaign management employment history.
That's a 5-year.
And then cross out. Yeah. Gene, try and fix bad wording and using your friendly amendment as an example.
Watching, yeah, I'm,
Does that accomplish what you were going to propose?
yeah, that's the same intent.
Okay. Melinda, do you see what we did there? Because the original wording was shall disclose their campaign, their employment by candidates for campaign management, which didn't make any sense. But all SREC members shall disclose their campaign management employment history.
I accept that friendly amendment if we can add previous 5-year
Hold on.
employment history.
Accept that at first, and then you can have somebody else propose
Okay.
additional.
All right, I accept that
Okay.
friendly amendment.
Thank you. Josh, do you want to be recognized?
Yeah, as a friendly amendment, Jocelyn SD 15, their campaign management employment history the previous 5 years.
Is that acceptable to the author?
Yes, it is.
Thank you. Does anyone else want to speak for or against the amendment? Seeing none, discussion's closed. We're now voting on the amendment, which is,
Mr.
Can
Chair,
we
point
see-
of information.
show the entire thing in red. Okay, I'm going to let you view that. And point of information, please state your point of information.
Craig Licardi, SD1. This vote that we're about to take is just on the modifications to that bottom section.
No, it is on all of the red. It is starting with proof of permanent residence in that Senate district, adding all language in red visible on screen.
Okay. Make a friendly amendment.
Point of order.
State your point of order.
Eh, Again, as I said earlier, this friendly amendment process, I understand it for time, but it's getting very confusing, and I don't think it's real parliamentary procedure to be just changing. That's completely different now than what we started, and the body did not take a vote, and this motion was on the floor. And now we're adding more friendly amendments, and we're getting confused where we are and where we're voting.
The friendly amendments were germane to the original amendment, and they explained and changed the wording of the amendment. It didn't change the purpose of the original amendment. However, you do get a chance to vote down the entire.
But are friendly amendments even in order?
Yes, under our committee rules.
Mr. Chairman,
Mr. Chairman, call question.
If debate's already closed, debate's closed on the motion. All in favor of the motion, please say aye.
Aye.
All opposed? Believe the noes have it, but I want to take a standing vote. Stand up if you are for the motion to amend. Please sit down. If you are against the motion, please stand. 1, 2, 3, 4, 5. Please sit down. The motion carries. Before we take, does anyone else have any Rule 42 motions
Mr.
proposed?
Chairman,
Yeah.
I'd like to propose a.
Hold on, I'm just asking if you have one.
Yes.
I'm not asking you to propose it yet. Anyone else have one?
I have one.
Melinda, you have another one?
Well, I wanna correct the strikeout and reword it. That can be
We can't correct that.
corrected.
Yeah, that's out of order. So Craig has a new motion on Rule 42.
42.
Yeah. Yeah, we are. Okay, we're going to take a bathroom break. We'll stand at ease for 12 minutes and 3 o'clock. Please come back at 3 o'clock.
It would have been really fast. Sorry about.
The 14-year-old shot to go to home during break in Manchester, Kentucky.
Yes.
Said no, take care.
Friendly amendments are
Are you get a coffee?
Sure. That's what I wanted. Oh, so like I've been like 3 times.
These happen in 20.
Just gonna have to go.
Just bring you a copy.
I found
That was correct. They're kind of convoluted. It is. All of that was added. Keeping the original thought was
and I knew exactly what you're talking about, but it was getting
yeah, it was very confusing how it worked.
Yes, I'm gonna.
I'll sign it. You know,
okay.
he's treating real nice because you're a fellow guy. Like these,
With following the rules and
yeah, but no,
no, I get it.
that's what I'm doing.
Okay.
Trying to use it. I'm gonna use the friendly bunch. Josh, I think you got fast.
Right.
Doesn't.
I agree.
The censure for.
That's the same thing.
It is. You don't have to go through amendment of the amendment to fix it. Vote again.
Yeah.
Metro County Sheriff's Office.
What
Up
do
on
you
the
deserve
website.
that to be in the.
Don't worry. Questions.
Everybody, please take your seats.
Another day.
Everybody, take your seats. Call the meeting to order. We are now in public testimony time. If you want to testify, if you signed up, I'll call you. We have 3 people signed up. If you want to testify after that, I'll call and you can raise your hand. Eric Blake. On deck is William Fuzi. Eric, go ahead.
Thank you, Mr. Chairman. Eric Blake, SD 22 Ellis County. I'm sorry if I keep speaking, but it's because I have a lot of things that the rules are dear to me, and you have some things that you can improve. So this time I'm talking about the debacle 2 years ago. Those Scantron votes. There was no security. We have photos of stacks of Scantrons being on a chair that anybody could have picked up, multi-marked it, voted multiple times on their legislative priorities or their platform priorities. No ballot security. How do you know that only credentialed people turn it in? We didn't even get the doors barred correctly before the vote happened. It is ironic to claim to be the party of election integrity when our own internal elections for our platform and legislative priorities are not secure. And the rules is where we can fix that. I hate to bring it up, but the 2020 convention, as bad as a dumpster fire of a convention as that was, had one shining star for me, and that was I had time to vote my conscience on all 400 plus planks and research every plank before I voted yes or no and feel good that, oh, I actually like my vote for once. Unlike all the other conventions I've been to where 30 minutes is not enough. I have to know in advance which planks am I going to go for, vote the no's on the ones I really don't want to see, and leave everything else blank because I ran out of time. Whoops. See the problem? We have technology that did not exist 50 years ago. We have the ability to do better voting. We have the ability to send a unique ballot per delegate and let them vote it at their leisure in the week following the in-person convention and say that the ballots are open for 1 week. Submit your ballot. All ballots submitted by this time certain will be counted. And even though the business of the convention is over, even though the amendments to the platforms are over, the voting is not rushed by how soon are we getting kicked out of the convention center. I urge you to consider amendments, whether it be to existing Rule 7, existing Rule 36, maybe add a new 36A, whatever the case may be. We can make rules on how we plan to handle the vote. We can make rules to say 400 planks is too many, cut it down that they can only provide a maximum of 300. Or we can say keep it at 400, but then instead of all 400, if all 400 get 90% of the vote, then all 400 become our platform. We could say you have 400, but pick your top 200 and only 200 planks go to the final platform. And that will encourage people to vote strategically on the planks that matter to them instead of being a sheep and voting yes down the entire column because that's all the time they have to do. We could.
That's time.
Thank you. I appreciate your attention to this matter.
William?
Hello, my name is William Fuzi. I'm a precinct chair, Henderson County, SD3. I'm speaking on Rule 44. Rule 44 is very important. It is about our only chance to meet our representatives where the rubber meets the road. I am required to represent my constituents. They are required to represent theirs. When our representatives decide to go off the rails and do their own thing, it makes it awful hard on us precinct chairs because we get questions first. What have you done? What are you doing? And not having any tools in our box makes it rough. Rule 44 was very important last year. The SREC decided to, first motion was to undo what the convention did. And that did not sit well with me. Knowing that our primaries are open and understanding that the elections have absolute consequences, Rule 44 became unbelievably necessary. Rule 44 became a last-ditch effort for the representatives to hold our representatives, or for us to hold our representatives accountable for their actions where their words don't match their actions. They can say conservative, 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 and then vote any way they feel like, and their actions are what caused it. The censures, there's a strict set of rules that are used. It took a lot of work to get those put in properly and worded properly. And we have an SRC that decides they're going to strip out language and take out charges of things that we voted as precinct chairs. So basically, they took away all the tools that we had. So having Rule 44 is very important to us. Thank you.
Thank you. Deborah.
Hello again. I am here to continue talking about the eligibility to serve on the executive committees and what you had just dealt with on Rule 42 for the SRECs of having conflict and not being paid because of undue influence or the conflict of interest is right on the SRC level. Now we need to bring it down to the county executive level. So we need that same protection. We need that same separation of conflict of interest. And again, this is not about any individual. As I said earlier, my county chair is currently paid by a state party. It has nothing to do with that. This is about a Republican form of representation that is free and fair and unbiased going forward, that there are no financial ties, there's no influence in on that. So it also should not be, we just struck the committee chair there, which makes sense because it was dealing directly with the SREC. And earlier I made a proposal to make this part of 8. So this also should not be about protecting an individual's employment. So I would like to make a recommendation and ask for this committee to please reconsider 8L, which has to do with conflicts. And that may be the right place for this, but is the recommendation, the amendment I would like you to consider, and I'll be happy to email this through my SREC, is no paid employee of the Republican Party of Texas or any county Republican Party or any paid employee employed by an elected public official shall serve an elected or appointed member of the county executive committee. And again, that is for all the reasons that we talked about, all the reasons why you just did for Rule 42 for the SREC. Those same applications need to apply for the county level. Thank you.
Thank you. Paul.
Thank you, Mr. Chairman. My theme this week will continue to be promoting Rule 44 and penalty number 3 and the spirit of accountability. Yesterday, I explained how we do not disenfranchise voters in an election cycle by disallowing somebody that does not meet Republican standards run. And we don't disenfranchise voters because they're allowed to go that cycle. We just don't allow them to use our platform again. But their message in 2025 was they shot the finger at us at the whole convention. We gave them our message and our priorities and we laid it out what we wanted, and they laughed at us. And what is this committee? This is Rules Committee. The very first thing they did, they went to the Capitol and broke rules. And then we were lectured when the SREC, when it became accountability time, we were lectured that we shouldn't treat them so bad. We're sitting here making rules. What would y'all do to me if I broke every single rule that y'all wrote? It wouldn't be a big deal at the convention. Y'all still wouldn't like it. These people broke rules that affect all 33 million of us across the state of Texas. Our legislature, they handle our issues of life that's right here in the sight of God that affect our families and everything. And this morning I gave you the disgusting details of all those reasons we need to have this accountability. And I urge you to take Rule 44 and penalty number 3 serious. And let's be a party that realizes what a standard is and stand by our standard to hold people accountable. And we did not go looking for a fight. They brought the fight to us. They sided with Democrats and they sided with the filth of the world. They sided with the Democrats, the same ones that sided with other DC Democrats, said Donald J. Trump deserved the death penalty and put him on trial. Yes, that's true. This is not made up. And so here we are, the great state of Texas, the Republican Party. Are we Republicans or are we something else? Thank you very much.
Thank you. Anyone else wishing to testify? Seeing none. Craig, we're on Rule 43.
Two. 42.
Okay.
Yes. Craig McCarty, SD1. Thank you, Mr.
Slap me
Chairman.
when I do that.
Have a
42. I never want to go backwards. Okay. Go ahead.
we can jump forward to 44 if you no, maybe not.
No.
All
Let's
right.
go.
So I sent the language to the secretary. It we received. Just read it out loud. Oh, where does it go? So where it says it moved. Where it says can you scroll up? No, the other way. There. Okay. Where it says it changed. Right in the center. No member of the SREC may be an employed lobbyist. So yeah, strike that and replace it with the language that I emailed. No person shall be eligible to serve as a member of the SREC while employed by, contracted with, or receiving compensation from any political campaign for public office, nor may any member of the SREC serve as an employed lobbyist.
Craig, how is this different than what we already voted on?
I'm sorry.
Is this different than the language we already considered and debated and voted?
It's at the beginning of that. This was the friendly amendment I was going to try to put in, but it was the uh, uh, employed by, contracted with, receive compensation, political campaign. That's new language. That wasn't in Prop 2. I mean, you can leave the no member may hold may what it said before. We can take that the lobbyist part in mind and leave the lobbyist part that's in there currently if you want to do it that way.
Is there a second?
Point of order, Mr. Chairman.
Yes, please state your point of order.
Mr. Chairman, I'm going to raise a point that this amendment is untimely. We spent the last 25 minutes debating the qualifications for office in regards to employment, any other compensation. I feel like that would have been more timely during that amendment to raise that as an amendment to the amendment. Therefore, I raise a point of order that's untimely and dilatory.
Yeah, I think you would have to do a motion to reconsider and add this as an amendment to the amendment. The chair rules, it does have the same subject as what we considered in the past. The same subjects being who is eligible, whether or not someone who is receiving compensation from a political campaign for public office, and whether somebody is employed as a lobbyist may serve as an SREC member. We dealt with that in the amendment before. The point of order is sustained. Is well taken. You can make any motion you want.
Second.
You make a motion to reconsider what?
To reconsider this item.
We're gonna have to pull up the entire amendment that we passed before and reconsider the entire amendment. So we have to figure out what the amendment actually was. Huh? No, we have to parse out exactly what amendment we voted on that contained that language.
So
We're
pull
gonna
it up.
stand at ease for 5 minutes while we
All right.
look back at the minutes.
All right.
Point of order.
Yes.
You're moving to reconsider. Can we vote before you go through and make a decision to try and figure out which part that you want to discuss?
Okay.
Let's say we vote ahead of time right now. If we want to
Would you like to make a motion to reconsider the amendment which contained that subject matter
Yes.
generally, and then if it succeeds, we can
Yes.
pull up the motion. Okay. Is there a second? Second by Craig.
Point of information.
Yes, please
The
state your point of
person
information.
making the motion to reconsider, did they vote in the affirmative for the amendment?
Did you vote in the affirmative for the amendment?
No. I mean, yes, I did. I voted for it. Yes.
He voted for it.
Oh,
So you may.
so point of order then, he can bring it to reconsider, correct?
Yes. Motion to reconsider must be made by a person who voted against the amendment. Point of order, well taken.
Voted for her.
Oh, it's on prevailing side. No, it's correct. He's on the prevailing side. My apologies.
Okay.
Point of order is overruled.
Good.
Yes.
Okay, there you go.
There's a motion to reconsider the amendment to Rule 43, which dealt with the subject matter. I think it was 42, dealing with the subject matter. It was Melinda Morris amendment, which was passed. All in favor of reconsidering, please signify by saying aye.
Aye.
All opposed?
Nay.
The nays have it. The motion fails. Any other motions on Rule 42?
Mr. Chairman, Brandon Moore, SDE 21.
Go ahead, Brendan.
All right, and Rule 42, and I did send this language to the secretary. Believe just put it at the end of the rule. I'm happy to move it wherever, but proposing at the end of the rule, language that states no person may run or file to run for more than one office of either National Committee man, National Committee woman, State Party Chairman, State Party Vice Chairman, or State Republican Executive Committee, SREC, as defined in Rules 40, 41, and 42 at a given state convention.
Yes.
Chris H, SD 14 seconds.
Motion by Brandon Moore, second by Chris Sasha. Brandon, do you want to speak to your amendment? Brandon,
Yes, sir.
you want to speak to your amendment? David, do you have?
Yes, sir.
Go ahead. However, it's the same ruling on Dan Hunt's amendment. The chair rules that the point of order is well taken and sustained. The germaneness to Rule 42, Brandon, if you want to repropose, uh, if you to repropose dealing with the subject of qualifications for SREC committee man, committee woman, you can do that.
Okay, I guess
Now recognize Brandon.
just need a little guidance on how to do that. I looked at them earlier, and due to the rule structuring, unless we were to put in basically a rule 43 and then renumber subsequent rules, which changes other numbering for things like censure and closed primaries, et cetera, that we dealt with already. I'm not sure where exactly we would place this, but I'd be happy to.
Mr. Chairman, point of inquiry, Andy Eller. I think I can assist with this.
Please state your point of inquiry.
Okay, would it be possible to say something like anyone running for state Republican Executive Committee may not run for any other party office, including state party chair, vice chair, and et cetera, et cetera,
Would it be qualifications? No,
I was like,
at the same time?
This is regarding the qualifications for SREC membership. So
Correct. So
whereas I don't think the way you phrased it would be germane, it would be germane to say that a person running for SREC may not have filed for one of these other offices.
Okay, then thank you for stating it. So that's my inquiry. So Brandon, there you go.
Okay, so
Yeah.
person
Let me continue to answer. Let me continue my answer. Rule 40 deals with national committee man and committee woman. Rule 41 deals with state party chairman and vice chairman and qualifications. Rule 42 deals with SREC qualifications. So whereas you cannot say that an SREC member can run under Rule 40 or 41, that would be germane to 42. What would germane to 42 would be nobody may run for state Republican executive committee under this rule who has, if they have filed to run for an office of national committee man and committee woman, state party chair under Rule 40 or 41. However that would be worded. It has to pertain specifically to the ability to run for SREC, not the ability to run for those other offices.
Mr. Chairman, Daniel Hunt, ST3.
Yes.
I think it's a point of information. If we put just, well, never mind. I withdraw. Never mind.
Do we have, Brandon, do you have another motion on Rule 42?
Yeah, I would like to move the language that you proposed. I'm trying to type it up right now and send it over.
I didn't propose anything. I was answering a point of information.
Okay, the language similar to what you included in your point of information answer.
My point of information answer.
Depends on what the.
Okay, we're waiting on that language.
We already have.
Do you have, does anyone else have a Rule 42 amendment in the meantime we can take up while Brandon's working on that language?
We went through that.
Okay.
When we were.
Do you have an ETA?
Momentarily getting over to the email right now.
Do you want to just dictate it?
Right now.
Sure. Let's see if this works.
Yep.
A person may not run for SREC committee man or committee woman
That's not because of.
If they have filed to run for state party chairman, state party vice chairman, national committee man, or national committee woman at a given convention or at a given state convention.
Does that accurately reflect your proposed language? Thank you. Is there a second?
Second, Becky Green, SD 17.
Second by Becky Green. Do you want to speak to your motion, Bryn?
Yes, sir. Simply put, a person can't hold more than one of the offices at a time, and we should figure out we're going to report it. It's similar to what we do with any other office that's on the ballot publicly. So I feel that pick which office you're going to run for and file and run for it.
Mr. Chairman, I have an amendment. Andy Eller.
Yes, go ahead, Andy.
24. I hope this is a friendly amendment. I hope you'll take it this way, Brandon. But if they have filed to run or showed intent to run, or language, because in the case of the committee, the national committee man, national committee woman, they just make their announcement that they're running, or say something like, or have announced they will be running.
Well, because we're doing this in reverse sequential order, I do have an amendment for national committee man and committee woman that require a filing deadline.
Okay, hold on. The friendly amendment does not. I reconsider the friendly amendment respectfully because the only talk of filing is filing for state party chairman, state party vice chairman.
Okay.
Okay.
National committee man is what you're talking about, does not have a filing requirement?
Correct.
Okay. So is your amendment to, if they have declared an intent, their intent
There you go. Intent
to run.
to run, yes.
Or filed to run.
Or filed to run, yes. That way, and Brandon, I think, well, Mr. Chairman, I think this just takes it up
Hold
in
on,
case we
hold
go.
on. Are you offering that as a friendly amendment?
I'm offering that as a friendly amendment.
Does the author accept the friendly amendment? You do. Okay. So the motion on the floor right now, does anyone want to speak for the motion or against?
Mr. Chairman, Andy Eller, I'll speak for it.
Carmen, do you want to speak too?
Yes, I want to speak against though.
Go ahead, Carmen first.
Okay, I was for it until the friendly amendment. How do we declared their intent? I mean, they posted on Facebook. They told their friend. I mean, any little thing they told someone they're thinking about running for it. It's just I think it's too broad, too open. And we just keep it filed and we fix filed in the subsequent rules that come up.
Thank you. Anyone else?
Mr. Chairman, I was going to speak for it.
Who's this?
Andy Eller.
What? Who just spoke? Andy Eller. Okay,
Andy
go
Eller,
ahead.
yes. Yeah, I was just speaking for this because at this point, yes, we do not have um, the filing period for the national committee man or national committee woman, although we may or may not fix that later. That's why I wanted to put the intent to run, and I did see our general counsel shaking her head. It's just like we do with independent candidates for election. As soon as they announce that they're going to run, that is their intent, and that's how the election code sees it. Now they've made their intent known. As soon as they say, even if you talk to people or you take any positive step towards that, you post it on Facebook. I'm going to run. Yeah.
Chairman,
yes.
Like Dave Wilson, SD, I'd like to speak against the amendment.
Go ahead.
I'd like to speak against the amendment and would like to I would hope that the person bringing this forward would table this until such time we establish some filing requirements for the national committeemen and committeewoman, and then once that is enacted, we can bring this back off the table with the proper language. In the meantime, I'll be voting against this.
Are you making a motion or are you just speaking against?
Yeah, I move to put this on the table.
Is there a second?
No.
Second by Justin? Okay. Any discussion?
I think I spoke to my motion.
Got it. Any other discussion? All in favor of the motion to table, please say aye.
Aye.
All opposed?
Nay.
Please stand up if you're in favor of the motion to table. Okay, please sit down. Please stand up if you're against.
We had another one stand up.
What?
It's not like Upchuck.
I got Chuck. The first time. Any abstentions? Okay, by a vote of 15-13, the motion passes. This motion's tabled. When do you want? The way I would suggest to handle this is let's finish addressing the Rule 42 amendments. If anyone wants to make a motion to take up 40 before 41, that will save us time because we don't have to take up a similar amendment on 41. If it's passed on 40, then we can reopen 41 and 42 for the sole purpose of dealing with the corresponding amendments.
Mr. Chairman, I'd like to move that we address Rule 40 now.
Okay. Let me ask, does anyone else have any other amendments to 42? If there's no further amendments to 42, we'll be moving on from 42. There's no objection, hearing none.
Mr. Chairman?
Motion on the floor. Please state your motion again.
I move that we address Rule 40 next.
Okay. The motion on the floor, is there a second? There is a second by Katie Jackson. Okay.
Mr. Chairman?
Hold on. The motion is to take up Rule 40 before 41. That's a majority vote of the committee under the supplemental committee rules. Is there any discussion? Yes, Matt.
I had a query.
Go ahead.
Sorry, I didn't mean to interrupt. I was trying to do it in between our debates on individual rules. You had sent out a spreadsheet with a lot of things that had been submitted from, I guess, the SD caucuses for rules. Are we going to take those up after we finish the list that Rachel has, or do we need to get those in during?
That is up to the individual committee members to review and propose as they feel is appropriate.
Okay, just checking. Thank you.
Mr. Chairman, parliamentary inquiry.
You say your inquiry.
Is there a way under our committee rules for us to sit there and deal with an idea that needs multiple rules conforming changes, simultaneous changes?
Yeah, it would be the same. It would be a motion to, it would be under the committee rules, a motion to take up rules out of the regular order.
Would it be in order to make a motion to suspend the rules, which I know is a 2/3 threshold, to be able to take care of these 40, 41, and 42 forming change on the subject as one amendment?
The answer is yes, it would be in order. I'm checking on the rules threshold, on the voting threshold. The answer is it would not be a motion to suspend the rules. It would be in conformity with the supplemental committee rules. We are taking up rules out of reverse sequential order, and that we would be taking up multiple rules at once. By a majority vote of the committee, that rule may be taken up out of order.
Is there a motion pending?
Yes.
There is a motion pending that's been seconded to proceed to Rule 40 out of order.
Would you withdraw to allow me to make a motion to allow us to take this as 42, 43?
I withdraw my motion.
Motion's been withdrawn. Chris, do you have a motion?
Mr. Chairman, I move that we take up and consider rules 40, 41, and 42 simultaneously for the purpose of addressing uh, the eligibility of individuals to run during a singular state convention.
Is there a second by Parker? The motion is to take up rules 40, 41, and 42 simultaneously for the sole purpose of um, addressing the motion to deal with all three rules. This does not mean that's the only purpose for which we will be taking up Rule 41 and 40. After this is done, we will then go to the regular order and take up 41 for other purposes. So you're not missing out on your maths. Is going to be germane to this particular motion that is being brought up. All in favor, please say aye.
Aye.
All opposed? The motion passes. We are now taking up a motion. Brandon, would you like to state the motion?
Yes, sir. In Rule 40, I sent language over to add at the new language prior to the new language at the end of Rule 40. That language is to be eligible. Candidates for the office of National Committee Man or National Committee Woman shall be required to file a statement of intent to run with the SREC Secretary by 6 p.m. CT Central Time, the 10th day prior to the first general session of the State Commission for which the election is to be held.
It's all to be on the same thing. That seems to be better.
He's doing this.
Brandon, all that's in order now is the motions dealing with eligibility.
Okay.
Specifically, whether or not filing for one office precludes the second office. That is the one motion that deals with that requires changes in 40, 41, and 42 simultaneously that we have gone out of order for.
Okay. Be similar language to what we proposed earlier, but give me just a moment and I will mail it over to Rachel.
We're going to stand at ease for 5 minutes to reconvene at 3:48 while we get the rule language set. So take a bathroom break if you need one. It's just going to be that first part. You're going to get to do the second part. That just isn't so.
Is this what we're talking about?
Person may not run for SRC committee but filed to run for state party chairman, state party vice president. Filed or given an intent or declared an intent to run. Filed or declared an intent to run. Everyone, a person may not run for chairman, vice chairman, filed or declared an intent to run. Or declared an intent to run for.
Presumably it's good.
Right.
At the same.
So you gotta go downstairs and get it, or bring it to the and then front of
Person now run for the file or declare an intent to run.
No room to create an
No.
I know.
that,
You're feel free to yell at you.
but they would work on that. So I think because she's free.
Yeah. Well, that argument directly with your AI. It's true. It's like,
Everything.
okay.
No more rule 45.
It could be. I can't say.
Well, we're not to be.
Mm-hmm.
So you're gonna change it. So let's throw it out there. Send her that. Well, no, I'm trying to think about how. I'm not sure being your consumer business. She's not over here with the holes.
Come on anytime.
Get all the way back to weird shaky.
You're all, yeah, but I'm saying, like, because we only opened it up. Good choice. Take care of
You
this.
send it to Rachel.
See what
He
before
just
we can
sent me
consider
something.
that.
That's what it is.
Before we can make another motion.
Okay, but also, so there's two.
He's not.
You run for multiple offices and then file 10 days in advance. That's what I'm getting. Dave wants that as well.
What do you mean?
So you know how we
We're already
had,
filed 10 days in.
no, only for state chair.
I have a separate one that I sent earlier for.
You're not the only one. Dave wants that too. So the have to file 10 days in advance. And
I have to
can't
take
run
that
for
up separate.
well, no, I don't think we can have a
Get exemption outside of district.
into 40.
What I have observed in the district.
Why don't?
Marine event or a cruise, let's carry this little box cutter with its.
So this is.
Yeah.
Well, plan to put a filing deadline for series.
Is that
Where it goes between.
I don't think you're gonna get it. Already have that. Yes, we're dropping votes as soon as
Okay.
that other which.
Okay.
I'm just saying. But if they've already voted on it. Three. It's like,
I mean, they're statewide.
Yeah.
Take it out of order specifically for what they're in there. There's just that in days. Thinking shouldn't dispute deals with 10 day. What are they?
We have to get to that phase before I can sit there and say, ultimately, if there's
The
like
rules, we don't have anything on general.
go and file a lawsuit. It'd be nice to.
Yeah.
Right, well, I mean, it's a binary.
10 days.
The rule 47 or something else, right? Either the state qualification disputes,
Do that.
resolved.
That's what I was gonna.
We have them resolved. Hey, so I can
We're doing now. Deadlines is a separate issue. You can take out the first. Like if we need a qualification.
Sorry, see,
I know
that's-
there's some. I think that's nice.
I mean, why would they be biased?
People are now, sorry.
Hello, but
Ending the rules will happen. We discuss it with your house, figuring out how to.
Stay away. The county had this problem. It's gonna sort it out. So, because we're really just doing this,
Especially
sit there and say that resolve it themselves. What's the qualification? So they're like, person may not run or in one office. A stating that. Yeah, like, you know, like a get a run. We don't have files, so it's filed in and we got up to you. Or national, if we're gonna assume that national's gonna get that intent, it'd be first
I know that.
or
First Wednesday?
any other office.
You get all day Wednesday.
Thing is, I don't starts admitted
No candidate can
intent to
file.
run is used at all.
Candidate.
But when it's used, well, how many local parties actually have? You know, running that's the other stuff.
I was just.
When you have it, I would rather Republicans make those and
It's good.
Well,
more often.
It's a lot better for them, but it's.
What's exactly the indictment. But it was helpful. vice chair. So somebody got an amendment that they're trying to.
That's great. But
I wasn't lazy. I read it. Pretty distinct chair, vice chair around. It's very well drafted. Somebody put it was perfect. I could come up with something that I could really wanted to. But again, the whole question is, without it,
he's an amazing lady.
that was fun. Say if you have a relative for others of Montgomery County or whatever county. The problem is that we just have that's we're not dealing with a jury doesn't understand public involvement. You know, I'm wrong on this, but just we have is you have like with law, we all go mile, right? You have a uniform standard of to qualification. And then the moment we do not have a uniform standard to how they control. It's a very parliamentary process. The other one is quasi founding. One is also and just I got it. So to me, it was the type of thing that it's that in. It's gonna and where way too early years later. I don't know why it's amazing that now filing yeah the filing they're really it's a big change. No. Where did it pass first time? It never before what? They're gonna reject the germinate yeah. But I mean it germinated for a while. Well, then also work with the first head or I watch that done with this. Amphetamine was time it was about
Wanting to add a 34.
True there.
That's only the children are But that's been so much. But short it is. Stomach.
Yeah.
Okay, everybody get back to seats.
Put this.
Stop on by anytime.
That'll submit and then some.
Howard Brothers live right there.
Okay.
You have it on any of your document, on your Q document or
It's on the general rules.
general.
On the live doc. Okay. Bring the meeting to order. Brandon's proposed rule changes of 40, 41, and 42 are on the live doc. We're putting them up on the board and we'll hold between them. Brandon, would you like to present your proposed changes?
Yes, sir. And this is for 40, 41, and 42. The language is very, very similar between the three. Essentially, it identifies the office for that role title. For example, in 40, it says a person may not run for national committee man or national committee woman if they have filed or declared an intent to run for state party chairman, state party vice chairman, SREC committee man, or SREC committee woman at the same convention. Similar changes to 41 and 42. It just identifies the applicable office for that rule first, and then the other four offices respectively. Otherwise, it should be basically the same language. Trying to save some time there.
Second. Dan Pickens, seconds.
There's been a second by Josh Flynn. And any other discussion for or against?
Mr. Chairman, Andy Eller, SD 24.
Andy, beat Chris because he was slow.
Oh, okay. Well, good. Um, would it be in order to say have filed for state party chairman, state vice chair, state vice chairman, or declared an intent to run for SREC committee man and SREC committee woman? Because you do have to file for the chair's position, but you don't have to file for SREC.
I I think that's a different wording that accomplishes the exact same thing as this wording. Anyone else? Chris, did you have something?
Craig Licardi, SD1.
Nope. Chris first, and then Craig. Chris, and then Craig.
Um,
Are you for or against?
For, but I would like to possibly make an amendment. That amendment would be,
Wait. Are you speaking for? Or are you making?
I am in favor, and
So
I'm
you're
making a motion.
Just making a motion.
Oh,
You can't speak and make a motion.
well, it's hard to debate. Anyway,
It's not.
I am.
Just make the motion.
All right.
Okay.
All right. My motion is to amend it to say if they have submitted a declaration of intent, which I believe is conforming with the language under the 10-day filing. The 10-day notice rule.
Is that in all three sections?
I would, and conforming to the same.
Not the SREC section.
Point of order, does that really change it?
We don't have a filing. All right, you know what? I withdraw the amendment.
Thank you. Filed or. Oh my God. Craig.
I give Craig Licardi, SD1. I would speak against this, the amendment. I guess, is this a single point of information, Mr. Chairman? Is this a single amendment that applies to all
This
three
is one
rules
single amendment with three sections,
in three different rules? Okay.
Three different rules.
Okay.
Yes.
I'm speaking against it simply because I don't think it's necessary. If someone's running for national committee man, the person's not also going to run for the SRC for the state chair. It's just not going to happen. And likewise, the committee woman is not going to, and it's a backdoor way of trying to eliminate the ability of people to run for both state chair and state vice chair, which again, because the TEC forces people to forces us to have a male female chair vice chair. It makes it impossible. It makes it impossible for someone to only run for one, and they can't. Trying to say if they lose a chair race, they can still run as a vice chair if the opposite gender wins the chair.
Josh Flynn, SD15. Can we get the author to explain that? Or do you, as the chair, recognize this point of information? Can you tell me whether or not this is legit or not?
No, I cannot do that. However, I can't speak to whether or not this allows the state party, someone to run for both state party chair and state party vice chair. Craig, specifically, there's no prohibition on running for state party chair and vice chair
In this amendment.
in this amendment.
Okay. Thank you.
Thank you. Anyone else for or against? Seeing none.
Mr. Chairman?
Yes.
So what Craig's point was wants people to be able to run for both chair and vice chair.
Yeah,
Correct?
Yeah, we dealt with that, and the point of information was you can run for both state chair and vice chair under this amendment, the way it's worded. Okay, we're closing discussion on the amendment. All in favor of the amendment, please say aye.
Aye.
All opposed?
No.
The ayes have it. The motion passes. We are back to Rule 41 in the regular order of business. Any amendments to Rule 41?
Mr. Chairman, Carmen Calderon, SD 27. I have an amendment that was sent to the secretary earlier. It's pretty simple. I'd like to strike the words 3 districts and add 5 districts, and then strike the words 20% and insert 30%.
Second.
Where is it?
7 or 70?
320.
Oh, 30.
Is there a second? Second by Dan. Discussion from
Chairman,
yes.
point of information or request for information. Do any of the changes that we're making right now apply to the current races already in progress?
No. Carmen, would you like to speak to your amendment?
It's pretty self-explanatory. I hope you guys vote for it.
Man of few words. Okay. Anyone else for or against? Dan, you're speaking for? Yeah.
We all heard Virgil speak earlier. I think we all pretty much respect Virgil, and I think his point was very well made. Thank you.
Thank you. Anyone else?
Mr. Chairman, I'd like to amend Andy Eller, SD 24.
Yes.
I'd like to move it from 5 to 6 and from 30 to 40%.
No.
I wasn't asking for a
I
friendly.
don't think it was friendly.
I wasn't asking for a friendly amendment.
It's a hostile amendment. This is very hostile. No,
I'm going to fight it out with you here.
second. We have an amendment and a second. Do you want to speak, Andy?
Yeah, I was just going with what Virgil had come up with. I think it, as he said, anybody who comes in under 6 or 40% of the delegation, they're just not a viable candidate, and it's going to just prolong us. As we're talking about in the future with presidential election years, it gets really, really tough, especially for business on Thursday and Friday, because we have to do national business on Saturday. That just drags out our floor time, and we don't have enough time to do debate on rules, priorities, and LPs on Friday. And that's why we always wind up coming back after the gala on Friday night, because we just don't have that time. And this will actually help us to get some of that time back.
Point of order. That completely changed my amendment.
It's not. You're increasing the vote thresholds. He's increasing it further.
Okay.
If he was lowering the vote thresholds, that would be contrary to your purpose.
Okay.
And out of order. Yeah, I do. Anyone else for or against?
I'd like to speak against the amendment to the amendment.
Go ahead.
I think that's too high of a threshold, and I think what I offered was a good compromise. We were at 20 and 3, and now we've bumped it up to 30 and 5. So vote down the amendment to the amendment and stick with the compromise.
Anyone else? Seeing none, we'll vote on we're voting on the amendment to the amendment. That is changing the amendment to 6 districts instead of, no. The original was 3. Carmen's amendment was 5. So a yes vote is to make it 6 districts instead of 5 and 40% instead of 30% for the proposed amendment. All in favor of the amendment to the amendment, please say aye.
Aye.
All opposed?
Hey.
The noes have it, the motion fails. Now we're back on the original amendment, which is 5 districts and 30%. Any other discussion?
Mr. Chairman, Andy Eller, SD 24.
Yes.
I'd like to speak for the amendment.
Go ahead.
Carmen, I was just trying to make it go a little bit taller, higher in the numbers, but
Short joke?
yeah, what?
A short joke?
No, it wasn't. I'm sorry, but I was trying to make it go up, but I am definitely for at least the 5. So I want to let everybody know that. And
Thank you. Craig, did you have something?
Yes, Craig Licardi, SD1. I'm going to speak against the amendment. 3 districts and 20% of the voting strength is a significant amount. That's 1 out of 5 out of all 6,000 people. I mean, it's weighted, so the number might vary a little bit, but um, that's a pretty significant amount for one campaign to gather that many petition signatures, um, and that reflects a pretty significant amount of people, delegates to this convention, and allowing that person the opportunity to make their case with 20%, I think is sufficient bar of entry. And less than that, they're at. But
Have information, Mr. Chair.
Who was that? Got it. Dan, go ahead.
Let me make sure that I understand the numbers. I'm a math major. Okay. But what the question has to do with, didn't we change it earlier that we're only going to allow the top 2 in a runoff?
We have changed the convention rules so the top 2 are in a runoff. Yes.
Okay. So if the top 2, I'm just throwing this out. Let's say it's 40-15.
No, the
It's still the top 2.
this is the floor.
This is nominations from the floor.
Right.
Add a possible third, which we've already said we're not going to do. Correct?
No, the nominations for the floor, who is eligible, are set by this rule. So you can
We
have
also
you can have
said we're
3
only
people
gonna take the
nominated
top
for the
2.
floor. We're talking about runoffs in convention and runoffs from those who are nominated from the floor.
I understand. So I do understand. I just want to make sure you explain that to everybody else so they do understand it.
Yeah.
The difference is.
So, for example, last election we had, I believe it was 4 or 5 that were eligible
Right.
for the floor.
We get
So
that.
among
He
those
just
5, you would have a
speak in favor.
floor vote, and then the top
He's
2
explaining it.
would then have a runoff under our rules that we just currently passed. Under this rule, perhaps 2 and 4 would have been eligible for the floor vote in the first place. Any other
Mr. Chairman, Dan Hunt,
Go ahead, Dan.
We got to understand there's 31 SDs,
Mhm.
so you could potentially have 6 candidates nominated, and you don't have to get both 5 SDs and 30%. It's 4, so you could still have 6 plus somebody who does the petition. So you could actually have even more than 6 candidates in a race. Somebody who gets less than 5, there's really no realistic chance they're going to win anyway.
So you are 4.
I'm a 4, yes.
Okay. Anyone else? Seeing none, we'll proceed to a vote. All in favor of the amendment, please say aye.
Aye.
All opposed? The ayes have it. The motion passes. Do we have any other on rule? Who else has amendments on Rule 41?
Mr. Chairman, Brandon Moore, SD 21.
How many do you have?
1.
And that's it. So we got one more. Okay, go ahead, Brandon.
1 on Rule 41. Towards there where it specifies the filing deadline of at least 10 days prior to the first general session, I'm requesting that we replace that so that then as by 6 p.m. Central Time of the 10th day prior to the first general session of the state convention.
Well, it says 59.6, but it does clarify. Is there a second?
I'll second that motion, Dan Hunt.
A second by Dan
SD3.
Hunt. Do you want to speak to your motion, Brandon?
Yes, sir, Mr. Chairman. While I don't necessarily think it's per se necessary, it does provide clarity. And there was a lot of confusion and questions about filing this time, since this was kind of the first time out the gate with this. This simply provides clarity by putting a time certain and I'm not married to the particular time. I would, others have suggested another time. I'd be open to a friendly amendment. As long as it's not midnight, it would have to be 11:59 or some other time.
Okay, anyone else?
What is up?
Chris?
Yeah, Mr. Chairman, I would actually move to amend it to 11:59. This is an electronic submission by email. It's not a open office that you're waiting to sit there and get perfect paperwork. I have to simply put in an email to probably Virgil saying, I would like to
So
run for chair.
are you making an amendment? Okay, wait.
I'm happy to
Let,
accept.
let me just say, I would recommend you do it as an amendment, not a friendly amendment, because I have a feeling that there are different views on 11:59 versus 6 o'clock. So we could just have a quick vote, take care of that issue, knock it out, and go to the.
Whether or not it's friendly.
Well, it's up to you on whether to offer a friendly amendment.
I'm offering.
Go ahead. You want to accept as a friendly amendment? Okay. It's a friendly amendment. 11:59. So currently on the floor is the motion to amend the deadline at 11:59 p.m. Central Time. Any other discussion? Seeing none, we'll move to vote. All in favor of the amendment, please indicate by saying aye. All opposed?
Hey.
The motion passes, and the rule is amended. Any other on Rule 41? Seeing none, if there's no objection, Rule 41 is closed. We'll move on to Rule 40. National Committee Man and Committee Woman. Do we have any Rule 40 amendments? Brandon?
Yes, Mr. Chairman, Brandon Moore, SD 21, similar to what we just did, but this is kind of an entire new sentence in here. To be eligible, candidates for the office of National Committee Man or National Committee Woman shall be required to file a statement of intent to run with the S3C Secretary by 11:59 p.m. Central Time of the 10th day prior to the first general session of the State Convention for which the election is to be held. What I submitted to the Secretary said 6, but since we did the other one at 11:59, I'm proposing that we do the same here. And forgot to mention earlier, but specifying the time deadline, I think, is a slight modification of what the party secretary, Virgil Cruz, recommended. But he did recommend setting a time certain.
Hold on. Is there a second?
Second.
Who was that? Greg? Second by Parker. Brandon, can you confirm the language? You confirm the language on the board? Brandon? We're good? Okay. We've had a motion seconded. Brandon, do you want to speak?
Yes, sir. Same thing as earlier. I think it provides a filing deadline, lets people know who's going to be running, provides for preparations for the commission. This is something Virgil recommended and putting the filing deadline in here for National Committee Man and Committee Woman.
Thank you. Any other discussion?
Point of information.
Yes. Who was that?
Central Time,
Gene.
daylight saving or standard?
Central Time would be the same as local time. So
It says CT.
right now it is standard time. Should we go to universal daylight time, it would be daylight time, but it doesn't change. So it's going to be the time that is currently in effect in the state of Texas, in Central Time.
Thank you.
That's why we didn't put standard time. That's why we put central. El Paso is not central. Okay. Any other discussion? Seeing none, we'll vote. All in favor of the amendment, please say aye. All opposed? The ayes have it. The motion passes.
Mr. Chairman, Andy Eller, SD 24, point of inquiry.
Yes.
Would it be appropriate at this point to standardize the 3 districts to 5 districts and the 20% to 30% like we did for the chair, vice chair?
I was about to make that motion.
That would be in order.
You can make. You want to make the motion?
I will then make that motion. I'd like to change the at least 3 districts to at least 5 districts, and then change at least 20% to at least 30%.
Second.
Who was that? Oh, Randy. Randy Dunning, second. Would you like to speak to the motion?
Yes, and I'd just like to say, you notice I did not go with 6 and 40. So I hope this is amenable to everybody, and this will standardize what we're doing with the vice chair and the chair. Thank you.
Thank you. Any other discussion? Seeing none, we'll move to vote. All in favor, say aye.
Aye.
All opposed? The ayes have it. The motion passes. Anything else on Rule 40? There's no objection. We'll move to Rule 39. Um, Hearing none, Rule 40 is closed. We're now on Rule 39. Is there anything on Rule 39? Seeing none, if there's no objection, we will close Rule 39 and move on to Rule 38, which is long. Yeah. National Convention delegates and alternates. Any changes to Rule 38? Hearing none. If there's no objection, we'll close Rule 38, move on to Rule 37. So moved. Rule 37, State Convention Exhibition Hall. Is there any changes to Rule 37? Seeing none. If there's no objection, we'll move on to Rule 36. Hearing none, we are on Rule 36, seating and voting. Is there any changes to Rule 36? If there's no objection, we'll move on to Rule 35. Hearing none, we are on Rule 35. Is there any changes to Rule 35? If there's no objection, we'll move on to Rule 34. 34A, I apologize. If there's no objection, we'll move on to Rule 34A. Hearing none, we're now on Rule 34A. Are there any proposed changes to Rule 34A?
Yes. No, I'm sorry. Oh, you moved on.
No? Okay. If there's no objection, we'll move on to Rule 34. Hearing none, now on Rule 34.
This is request C23, Assistant Secretary Amendment for 34 Section D, having to do with allowing the SRCs to authorize money for promoting legislative or party principles from the platform. That doesn't seem germane.
Not germane.
Okay.
It mirrors the language from the legislative authority board.
I don't think that's not germane. Mr. Chairman,
Yes.
Daniel Hunt, point of order. I don't know that that's germane to this.
Point of order sustained. Any other changes to Rule 34?
Yes.
Go ahead.
I feel like I'm fishing here.
I submitted a change to Rachel.
After Eugene submitted a different change?
Technology. I was in the oil industry.
Still on 34.
What was the change? Oh, you just sent it.
The change was to go along with the change I submitted to Rule 43A, to properly place at this point in the rules what the responsibilities of the platform committee are.
We didn't. Yeah. We have it. Thank you. Put it on the board and then call and then get a second.
Again,
Let's set it to change.
Does that accurately state your amendment?
Uh, yes.
There's a second.
Second.
Motion second. Gene, you wanna speak?
Again, I submitted this because it seemed like Rule 34 was the proper place to document what the responsibilities of the various committees are.
Thank you. Anyone else for or against?
I'd like to ask a question. Is the intent of speaking paper, is your intent that we have each of the platform items on a individual Scantron, or that we simply accept this as a report from the committee?
My motion doesn't attempt to define that in any way.
You.
The standard way that we have been dealing with approval of the content of the platform, I have no reason to change that.
Thank you. Anyone else? There's no other further discussion. Discussion is closed. We'll move to vote on the amendment. All in favor, please say aye.
Aye.
All opposed? The ayes have it. The motion passes. Anything else on Rule 34?
Mr. Chairman, I had one on 34C.
Okay. Kathy, do you have a Rule 34 amendment?
Yeah, she's got it.
Okay.
34C.
Raise your hand if you have a Rule 34 amendment. Just trying to get an idea. So we got two more, and you each have one, right? Okay, Matt, go ahead.
Linda has one.
And then Linda has one. Okay, three.
Yep.
Please, your amendment.
Yep. So my amendment is basically to conform legislative priorities to make sure that each legislative priority references one and only one plank from the convention, or from the platform, excuse me.
Got it.
Yep, that's correct.
Does that accurately state your amendment?
Yes, sir.
Is there a second?
Second that. Andy Eller, SD 24.
Second by Andy. You want to speak to your amendment?
Thank you, Mr. Chairman. Legislative priorities has been around for, I think, about 10 years now. And for the first 3 cycles or 4 cycles, it was always tied very tightly to the platform itself. The priorities were created for purposes of zeroing in on a limited number of planks from the platform that we would work hard to get passed into legislation. And it was always the intent when we created the Legislative Priorities Committee that it referenced the platform specifically, an individual plank from the platform. We've kind of drifted away from that the last 2 conventions, and this last cycle, we didn't reference the platform at all in the legislative priorities, and we ended up with a lot of very broad statements and broad planks for legislative priorities. So what I'm doing is sort of tightening that up and making sure that we keep the legislative priorities focused on priority planks from the platform. The platform is our statement of policies, and LP is not supposed to be creating their own statement of policies. that may even conflict with the platform or include things that are not in the platform. So this makes sure that we're all aligned properly and fulfilling the original intent of the legislative priorities. So with that, I yield back.
Thank you. Anyone else?
Mr. Chairman, point of inquiry, Andy Eller, SD 24.
Please state your inquiry.
So in effect, my question is, so in effect, would this change what we have today with just bullet point items to something like, for instance, plank 221 on fair election procedures has 20 some items in there. So would that be allowable then as a single LP, but you couldn't add other things from other planks, such as plank 221?
May I respond, Mr. Chair?
Yes, you may.
Yeah, that's actually the intent. That's exactly what I want to do. I want the legislative priority to say, we support plank number whatever, 221 with the title, and then everything that's on that plank is fair game for what you're doing with that LP. Yeah.
Yes, thank you.
Anyone else?
Greg Licardi, SD1, speaking against this. Each of the three committees, rules, LP, and platform resolutions, each three, we do all the heavy lifting for this convention. And so what this does effectively is we're tying their hands to be able to do the job that they're supposed to be doing over in LP. I've been over there before, and they spend the bulk of their 3 days wordsmithing and getting the wording just right. And if it incorporates two or three elements of two or three different platforms or platform planks into that are all dealing with the same subject, the same topic, that becomes a legislative priority. It may be broken out into two or three or four different planks in our platform, but this language would tie their hands and cause them to not be able to do their job effectively. And so I'm against this amendment.
Thank you. Anyone else?
Mr. Chairman, I'd like to speak against.
Go ahead, Chris.
I'm agree with Mr. Licardi in the sense that it seems like we're binding the committee to knowing what the platform committee is going to approve prior to them being able to produce their own. And we also don't know what's going to happen on the floor. We do this plank by plank voting. If that plank gets knocked out, but the priority stands, that I just feel like that there's technical issues, though I do appreciate the sentiment of what's trying to be conveyed. So I'll be voting against.
Mr. Chairman,
Mr.
can I
Chairman?
respond to that?
Yes.
I think for the last 4 conventions, the lowest amount of voting for a particular plank was around 86%. So we don't have planks that get knocked out. We haven't had that in my memory in all the conventions I've attended. That's a little bit of a red herring. Having served on platform for 4 cycles, I can tell you, and the people who've been around since when LPs were created and serving on platform or on the original LPs, yes, they're supposed to be tied to the platform, and we very frequently had communication back and forth between the platform committee representative and the LP committee representative within a particular district. They'd be running back and forth, talking to each other, and there'd be feedback. So it actually links the platform and the LP closer together, which is good. And that's the objective, and that's the original purpose of LP, that it should be. If you, in the big debate, when they were 10, 12 years ago, they were first talking about creating an LP, was the LP committee would become disassociated from the platform, and they'd be creating their own little mini platform. And that's what you're arguing for. If you say you don't like this and you don't want them to have to be bound by the platform, they are supposed to be bound by the platform. The platform is our statement of policy for the Republican Party of Texas. The LPs are not supposed to be our statement of policy. They're not supposed to be able to craft things independently of the platform. So yes, they should be tied specifically to one plank for each LP they have. That's the reason that the LP committee was created. They're not supposed to be functioning as an independent third party, doing their own thing, isolated from or independent of from the platform committee. So that's the whole reason I'm trying to do this. It does bring their hands a little bit. It's appropriate that we do that because we need to be referred back to the work that the platform committee does. and not creating their own independent planks, absent any relation to what our official policy positions are, all of which should be contained in the platform.
Mr. Chairman.
Mr. Chairman, I'd like to make a motion.
Randy, go ahead.
I'd like to move to make an amendment to the amendment. Replace the words "and only one plank" with "one or more topically related planks."
Second that.
Hold on.
Who's the second? Gene? Randy, do you want to speak to your amendment?
I think this would address some of the main objections while trying to preserve a tight coupling to the platform. I say this because we sometimes have 2 or 3 abortion planks. We sometimes have 2 or 3 Second Amendment planks. And if the committee is given the latitude to take those planks, convert them into a legislative priority, I think that gives them more purchase in this task, without saying we have to choose between one of the 3 abortion planks that we like but we like all 3. So I think the term "topically related" would solve that problem and might prove to be a good compromise between the 2 positions on this.
Mr. Chairman, point of order.
Please state your point of order.
Dave Wilson, SD 11. The amendment to the amendment is effectively negating the original amendment of being focused on one platform plank.
Okay. The original amendment. So the current rule does not bind the Legislative Priority Committee to party platform planks. Matt's amendment seeks to limit it to one plank per legislative priority. Randy's amendment to the amendment also seeks to limit from what we currently have, albeit not nearly as much, or much at all. So therefore, it is not contrary to the purpose of Matt's amendment, which is to limit the platform planks to which the legislative priorities apply. Therefore, point of order is overruled. Any more discussion on the amendment to the amendment?
Yes, Mr. Chairman, I'd like to speak against.
Go ahead.
I appreciate what Randy's doing in seeking a compromise, and the only reason that I would sort of be reluctant to do that is a couple of cycles ago, we used to have every plank was very specific, and we had a lot more planks. And a couple of years ago, we changed the way we did things, and some of our planks went from being, very narrow, sort of 2 lines, 3 lines, to being very broad. And as Andy mentioned, for example, in election integrity, it has a lot of subsections. So you can limit it to one plank and still have a great variety of things related to that topic that you can work on bills on. So I think, and that's the reason that I think one plank is enough. If you read the platform, you can pick different priorities from all the different sections in the platform and still have a fairly broad amount of legislation that could apply and be captured under that plank for you to support. So that's why I think one plank is enough.
Mr. Chairman, may I address that?
Yes.
Yes, and I appreciate the SD16 representatives' desire to tie it to the platform. I share that goal. I am not in great opposition to what he was doing, but I think for this to actually survive, it does not hurt to tie things topically. In fact, Matt didn't even defend the thing without having to use my word topic. And I would like to keep it to topic because that way we still tie it to the platform. Yes, we've unified many platform elements, and that's great. I applaud that work. But by the same token, especially when new platform elements come in, sometimes they don't get unified, and this would allow that to be combined properly into a legislative priority.
Mr. Chairman, Dan at STG.
Who else? Carmen?
Point of information.
Go ahead.
Is the chair advised if topically could be construed to a whole section of the platform because they're all within the same topic?
I'll answer it with a circular reference. Topically means topically. Go ahead, Dan.
Mr. Chairman, something I think we need to consider is a lot of delegates are asking
For or
us.
against?
I'm sorry?
For or
Oh,
against?
for.
The
For
amendment
as
to the amendment.
Yes.
Yes.
A lot of delegates are asking us to add more legislative priorities by being able to have several different planks addressed in one legislative priority. That prevents us from having to add more legislative priorities. If we're going to keep it to one platform plank, then there's going to be a lot big push to add more. I think 8 is a good number, and I think we need to keep it there. But I think being able to add more from a topically appropriate subject, I think, is a good thing. So I'm for.
Okay. Anything else? Yes, Dan.
Dan Pickens, SD20. I'd like to speak against the topic method. I like specifics. If we tie a legislative priority, even if we have 4 or 5 different sections or topics on pro-life, identifying one is enough. I don't know why we want to go forward to the topic method. I like specifics, and it shows direct correlation between that's in the platform and that's in the legislative priority.
Thank you. Anyone else?
Craig
Craig.
McCarty has
Chairman,
one.
I have, I want to speak for.
Okay. Craig, are you for or against?
Go ahead.
Linda, go ahead.
I believe that several of the legislative bills that were passed this session probably contained a couple of planks with similar topics. So, if the purpose of these planks is to stimulate the production of legislative bills, then it would make sense that if these senators and representatives are going to group these planks into topics to use for their bills, then it would be this amendment would be appropriate.
Thank you.
Craig McCarty, SD1. Just reiterate what I said previously is that
For or against?
For
The amendment to the amendment.
for this amendment to the amendment. Um, because it gives the Legislative Priorities Committee the freedom to do their job, and it doesn't hamstring them to tying them down to just the language in one single plank for a legislative priority. We have issues that face us, and we've got multiple platform planks that deal with them, and so we need to have they need to have the latitude to be able to address that effectively, and tying them down to just a single platform plank negates the ability to do that.
Okay, thank you.
Chair, speaking against.
Right.
I've been on SREC for 6 years, and I've never served on legislative priorities, but a lot of my friends have, and some of them are on the committee. I hear a lot of comment from them every cycle for how hard they're working and how many things they have to do. And while I've always sympathized with that, I've always thought, well, it's your job is entitled in the title of the committee, which is priorities. And as Dan said, the whole purpose is to focus. So the broader you make the priorities, the more work there is, the more overwhelmed the committee is, the more bills there are to follow. And we need to focus on specifics and not be so broad. And I think Mr. Dunning's well-meaning recommendation here is a little overly broad, and it takes us back into it's an improvement in where we are right now with being completely untethered from the platform, but it still leaves the door a little open, a little too wide. I think we should ask the LPs and direct the LPs to focus on specific things, and the planks are broad enough to give them plenty of meat to work on. So one plank for one priority is a perfectly well aligned rule for us to have.
Thank you. Any other discussion?
Mr. Chairman. John.
Okay, John.
Okay.
For or against?
Against. Matt's completely right. And these LPs were constructed to be very specific. And we've gotten so broad that once again, now we're looking at 80 plus bills that we're tracking for this. And even some of the people that the other people want to, I think Rachel said execute or commit to death or something like that, are sometimes going to get one of these right. Not that that's here or there, but Matt's dead on. We've gotten way too wide with these LPs, and that's concerning.
Thank you. Any other discussion?
Mr. Chairman, Brandon Moore, SD 21. Is there time left for against?
You have 1 minute.
Okay. As someone who works in the legislature, it's and has been involved in the party, I think our LPs are very, very important. I think what Ms. Patrick's approach here is in the original motion is good. I oppose the idea of broadening this because if we get too much of a smorgasbord cornucopia approach, we water it down, people stop paying attention to it. I'd recommend voting no.
Thank you. Any other discussion? Hearing none, we'll move to a vote on the amendment to the amendment. The amendment to the amendment is replacing the singular platform plank per legislative priority with the topically related language that's shown above. All in favor of the amendment to the amendment, please say aye.
Aye.
All opposed?
Hey.
The noes have it, the motion fails. We're back on the original amendment. We can get it up on the board. Against. Okay. Now we're back on the main motion. Any other discussion on the main motion?
Mr. Chairman, Andy Eller, SD 24. I'd like to speak for the amendment. As a member of the LP committee, I was also chair of the elections committee with SRC, as well as chair of the election integrity subcommittee for the LP. We would meet every Saturday for 3 hours during the entire session. I don't know if you realize how many hours that is. And just to go through each and every bill that was filed on elections, and it amounted to probably over 500 bills that we looked at, narrowed them down as best we could, even with these overly broad categories. By doing this and narrowing it back to one platform plank, which, by the way, in the platform for elections, for instance, there's a couple of just main categories. There's one on voter registration, and there's a platform plank on elections, basically. There's some other smatterings of bonds and some other things, but this would really help us focus so we wouldn't have to spend so much time in the LP committee or even the elections committee. I'm telling you, we spent ungodly hours that really tire us out. And when people talk about trying to expand LPs from 8 to 10 or 12, that is just nuts because there's a handful of us that work our tails off during the legislative session. So I'm all for this amendment.
Thank you. Point of information, go ahead.
Josh Flynn, SD15. Do you know how many legislative priorities were passed um, as far as legislation is concerned, based on the work that you did?
Andy, do you want to address that? Or are you asking who you?
Yeah, I'm asking. I actually know the answer to that. It's just like there were 43 bills passed based on our legislative priorities last year, the 8, and that was with that broad stroke. If we narrow it down, is our unintended consequences going to narrow our 43 to 25, and we're going to be happy with that?
I don't think so. We actually, on the election side of it, we had, depending on how I counted numbers, it's 7 to 8. We also killed a couple of very bad bills. But I also when you look at numbers, that's only 10% of the bills that we endorsed, because we basically had to endorse tons of bills because it was so overly broad. If we had been able to concentrate on maybe half a dozen bills instead of 80 bills, it would have gone a lot easier.
Mr. Chairman, may I speak for the amendment, please?
Yes, you got about 30 seconds.
30 seconds. Dr. Morris, SD13, Chairman of the Secure the Grid Subcommittee. We met weekly from November until June. We passed 11 bills. We worked our asses off. We held seminars. We went to the Capitol. We had legislative priority days. We've become the lobbyist for the RPT. And we passed more bills than they've ever passed before, and it's because we worked our ass off. So if you don't want to work your ass off, don't get on legislative priorities.
Okay, time's up on 4. Any other discussion against? Hearing none, we're going to move to vote. All in favor of the amendment, please say aye. All opposed?
No.
The ayes have it. The motion passes. Anything else on Rule 34? We got Melinda, you had something?
Sir.
Okay, you have one, correct?
Yes.
And then who else has one? There's 2 more. That's it. You can come and approach if you want to work on it with her.
Yes, sir. I've added one line to the end of 34C.
Okay.
And basically, it speaks to what I was just.
Hold on 1 second. Let's get the language up.
Right here.
Okay. So the line at the end of 34C is the SREC shall expend reasonable party resources to promote passage of legislation crafted in support of these priorities in the platform's preamble and principles.
Yeah, and it speaks
Is that
to what I
correct?
just spoke about.
Is there a second? It's that underlined up top. Second by
second.
Brenda. Okay, do you want to speak, Melinda?
This speaks to what I just mentioned, the fact that the Legislative Priorities Committee's become unemployed lobbyists for the RPT. And with all the work we're doing at the Capitol building, our Legislative Priorities Day, we visited every representative office, every Senate office, passing out information about our priorities. And so this is to ask the RPT to just throw us a few little resources to help us accomplish our goals.
Any other discussion? Anything else? Yes, Dan.
Daniel Hunt, SD3. Point of order, is this germane to this section of rules? This permanent committees and compositions. That it's a good amendment, but I don't think it goes in this section.
Point of order is well taken and sustained. The
That's the committee finals. I think that is 6:30.
she's working on hers. Okay.
Sorry, it's like it's right there.
Yeah, it's both. Okay, so we're at 4:50 now. We have one more amendment to Rule 34. Let's stand at ease and reconvene at 6:30. Go get dinner, come back, and we will reconvene at 6:30, take up the last on Rule 34. If you have any other amendments to the upcoming rules, 33 probably through 25, submit them to the secretary, please, during the break. Congratulations.
So much is down. No, if we resources can be, take it to resources, we can do it, we can make other changes in our bylaws. Please, that's where the changes are.
6:30.
Say it out loud. Say it. Yeah, I don't say it out loud. We'll take letters or something, you put so you were happy. Daniel Hunt, yes, sir. Yeah. But some of them will. Some of it, I'll stay. There you go. Well, where? Should I go? It's settled local. I learned that, whenever they say,
I'm gonna. Question. Hey, you're it's all yes. Yeah. Well, I will say that we don't know that they will have. So it's it ragged something you virus. No. Right. CRC government. Well, the guys like kind of yes. I don't think I'm going off for guys. Probably a lot. Not a friend. Not a friend. You're busy. I'm not making the stuff down. Going for the top. Why should I done for anything? I don't know. Where you go? What did the company? Is that a good minutes? Come with us. I just yeah. We got all night. They don't see pump hours. I think it'd help us. Yeah, I think something we can say. No. Hi. Anyway, I'll let you take the number. Sorry. Yeah. I gotta go get some. Or I got. Yeah. That might be. It's a Thank you. Here. Check. Oh, you got Jen Solar. I just. Great baby. Did I put collar? She says. But I think you better pick it out. We can't do more than this. Or did they know? It's here. Okay, the taco stand, that's 2.5 miles.
That's right. Catty corner from the hotel.
Oh, yeah.
Okay.
Okay, what is it?
It's, I don't know. It's American. There's this right between our two hotels.
I've heard about that one before, but I don't know.
And then there's the one in our hotel, and then there's that one.
I'm living. I'm doing okay.
These guys aren't open either, so those two are out.
Yeah.
There is Saltgrass too. She's not gonna want to go far into that.
Yeah, I agree. Neither do I. I don't have to want to go for it.
Right.
Guess it's a pull out. No,
Those are the
nothing
closest.
here. I go left the highway.
Not really.
Tuxedos.
There's 40 over
There's
here
those.
together.
Hey. Was fine, but it wasn't. Those
Right.
are the only two things nearby.
Yep.
Everything
Else is outside.
No. You got one for those two.
Okay.
There's a place downstairs here. I forget what it's called.
Down here, only Papa goes.
You know,
Papa
there's one
goes.
with the crow.
That's outside.
to dinner now? Yeah. Where are you gonna go? I don't know. We were thinking Papacito, Saltgrass, or what's the one that's right down here too?
That's in. That's down on the green.
Saltgrass.
The Saltgrass? Okay.
And there's Papados. You were it yesterday.
Yeah. Good, but I think probably Saltgrass or Papacito. It's like.
Okay.
It's
If you can give me 15 minutes, I'll.
Well, we're probably trying to go find a spot or whatever.
But
and
that'll
I'll
work.
shoot you a text.
Okay. Perfect.
Uh,
Back what? Huh? Yeah. Why not? That's time for at least tuna tartare before we have to get back, huh?
This just makes that explicit, that if we don't come to an agreement in that organizational meeting, sometimes they're really late on Saturday night, and people just want to get out of there. This would just explicitly give you a previous bylaws to start with at the first quarterly meeting. Similarly, H is just a clean thing to make it more modern that it's the precinct chair reports to the precinct chairs. I think it's I put semi-substantive in there because I understand there's some counties that are not doing this now, but I think they certainly should. Some growth this morning, I believe it was, that related to sections 8K, 8, where you're dealing with reasons for removal of a county chair or an SREC member, remember all those, they don't really fit with the rest of Rule 8. And we've known this for years. We never seem to get around to fixing them. So what we suggested, leave the language completely up to you, as suggest any actual changes to the language, but that and that deal with disciplinary actions, that be moved to a major heading. And what you call it, it could be, disciplinary actions or something maybe a little more creative. But just take those disciplinary ones out of the longer list of 8, which mostly deals with procedural things, just so where maybe it would start making a little bit more sense. I didn't try to adjust the language in any of those. Rule 13B and C quorum requirements. This has been around as long as I've been coming to conventions. Generally, late in the afternoon on Saturday, there'll be a quorum call. And the language has been just like this as long as I can remember. And the current language is not explicit as to the 3 criteria that constitute quorum. And when it happens, there's always the thing, well, it should be an over after the first 2 of those so that you can meet the quorum in 3 different ways. And in practice, that's what we've done in those cases, but we've never actually changed the rules to reflect that. So I consider that a cleanup because it's just cleaning it to what the actual practice is when that happens. Probably the most important change I can see in this is 23A. And this is dealing with delegate allocations to the state convention. And if you remember, there's tables where you get, I think it's currently 1 delegate for every 300 gubernatorial votes in the previous election. This number changes from time to time, but the problem is it's never the right number. And so you get people sometimes relatively inexperienced that are trying to put together their county or they get 1 for every 300, but a letter from somebody on staff says they only get 1 for every 368 or whatever. And that's because of the part 2 of that rule, which forces the total number to be between, I believe it's 7,500 and 9,000. And so what I suggest is we get rid of those explicit delegate applications that are wrong to begin with that they voted on and leave it up to the chair and staff with the approval of SREC. And again, I'm not married to the language, to simply tell everyone what that application is for the upcoming convention. And how you structure that look is particularly important. The convention records, that is substantive, what some people would call substantive. I don't think it's major, but it adds Republican elected officials and candidates to those that can get the convention delegate list. And candidate a number of times. I think this is something that the goal, once we get to convention, the goal is to win races in November. And if we say our own elected officials can't get those lists, you're string yourself in a November election. Those lists are invaluable, frankly, because most of the public lists that are out there are not very good. This represents the activist of the activists, so it potentially can help your congressional, your school board races, whatever it may be. Jumping into it's a minor change, but I think it will be important for winning in November. I'm almost down to 33. It's permissive. It's permissive only that a committee may have in its committee rules that every member fills out a conflict of interest disclosure. And we did this 2 years ago, and I think everybody complied with that. So it seemed to work pretty well. Maybe down the road it become a mandatory thing, but now it's just progressive to get the jewels from. Legislative priorities. I want a suggested change to address what Matt asked. Y'all are tightening because we need, frankly, some legislative priorities that were so that and I believe it was Matt said the legislative committee SRC simply could not keep up with the sheer number of bills to try to see if they fit the priority. It kind of got where it wasn't a priority. We've several years where a single priority
practice anyway, in that we currently have a grammar, spelling, punctuation, and formatting committee at the convention, but invariably we don't catch everything with that committee, and there still ends up being things that are they're either inconsistent throughout a document or they're just mistakes or they're typos or whatever. What this would do is codify what we normally do anyway and have a formal committee chaired by the secretary of the party and other appointed members, and it would be subject to the SREC approval with what they come up with. And it's non-substantive changes only. I think you've handled it all right, but on Rule 41, instead of what y'all came up with, I was just going to refer back to 1G and make the 1G the defining part. And with that, I thank you for your attention. Having chaired 3 committees, I really, really appreciate the work and effort that you and your family put into this convention to make them all work. And I can guarantee you that when it seems like everybody's fighting, at the end of the day, when you come out of permanent committee, you'll have a really, really fine document. So that's all. Thank you, Matt.
Thank you. Appreciate it, Mark. And we're back on Rule 34. Ms. Jackson, you have an amendment?
Yes, sir. Katie Jackson, SD 18. I have a addition for Rule 34, Para C, which has already been sent to the secretary. We straightened it out, got it all correct. And I really don't want to read all of that.
That's okay. It's up on the board for everybody to read. I'll give you a chance. second line from the bottom should be. Reserved out. One up. Is there a second?
Mr. Chairman, Brandon Moore,
Yes.
SD 21. For sake of discussion, I'll go ahead and second.
Second by Brandon Moore. Katie, do you want to lay out your amendment?
Why, yes, sir. I would love to lay out my amendment. All right. Essentially, what this does, the short form is we've already got state legislative priorities. We need federal legislative priorities. We, the Republican Party of Texas, should be instructing our congressmen and our senators through the convention process on what we expect from them. No. So that's really what this does. What it does is it parallels the federal priorities parallel the state priorities. They would come the priorities committee would come up with 15 of them. We would vote the top ones, blah blah blah. What this does is it actually opens up a little bit on the Senate legislators, because for the Senate legislation, you can't really send federal things to them. They can't do anything except, do a resolution that says, yeah, we support this. Well, that doesn't do anything. If we're telling, all of our Republican representatives in Congress, hey, we really want the SAVE Act. And here it is in writing, and the entire convention voted on it. Maybe that'll give them some oomph to get off their tails and get SAVE Act actually passed. Both sides of the house. So basically, that's what this is. Federal priorities and state priorities. It's a little bit of extra work, costs us nothing, and it gives us the ability to tell Congress, hey, this is what Texas wants, and darn it, we're Texas. So.
Thank you. Anyone else speak for or against the amendment? Justin?
Its current form, I would be somewhat against it, only because this appears to limit and I'm happy to offer an amendment after this, but this appears to continue the practice of 15 resolutions for state priorities and opens it up to federal priorities without a numerical limitation. That appears to me that it would open Pandora's box and multiply the work of the Legislative Priorities Committee, seemingly without limitation. Not that I have that much of a problem with lots of priorities, other than the more priorities you have, the less important each one becomes. But I think that in its current form, it needs to limit it so that we have a legislative priorities that can practically get all of this new work done. Not new work, but more intricate work done and hammered out in a way that meets the time requirements of the week-long convention, but also meets the time requirements required by have delegates, the entire delegation, cast another floor vote essentially on Scantrons, I think is how or by app, how we do it now. And so this doesn't seem to take those two concerns into account. So I would ask the author if there may be something that she would be willing to amend, because I think in theory this is excellent. In practice, this doesn't seem like this may end up being a little more confusing than the problems that it seeks to solve.
Can I go ahead and answer that, Chair?
Go ahead.
Okay. Didn't think of that while I was writing this out. Thank you for that. I know that when we vote for the 15 states, we only take 8 priorities. And we could do the same with the federal, or we could reduce it. I don't want to say I'm not married to these numbers, but I'm definitely open to negotiation. I mean, I think we really do need to have federal legislative priorities. Maybe going the whole 15 is too much, course, we wouldn't be doing this now. We wouldn't do this till next convention.
Would
But, I mean, how about,
But-
we go with 10 and we get 5 resolutions for the feds? I, I think we're not tapping into what needs to be tapped into for what we can put forward.
Thank you. Any other discussion? Yes.
I don't want to raise an objection that the whole thing's out of order, but I do think that this is not presented
Against.
correctly because it
You for or against?
displaces what we just did.
For or against?
Well, I'm against the resolution the way it's written because it displaces what we just did. It repeats the language that was in there before the amendment that we just passed. So we either need to adapt the language to what we just did, or I think the whole thing would be out of order and needs to be shouldn't be considered list.
Anyone else?
Mr. Chairman,
Yes.
John SD 31, against. We have a legislature in the state of Texas that meets every 2 years, somewhat in relation to the state party convention or the state convention, Republican convention that we have every 2 years. We can identify legislative priorities that will be coming up again in January and work for them. We have a Congress that meets all the time, and we do push legislative priorities with them, just like we did with the 22 convention whenever we submitted resolutions to the convention and got them passed on things like the vote. I don't believe this is workable in a workable fashion, and I don't believe it's needed.
Mr. Chairman. Mr. Chairman.
Dan.
Mr. Chairman.
Yes. Dan
SD6,
Pickens.
Robert Garay. Oh,
I'm getting Dan Pickens real quick.
okay, go ahead.
Ben?
Dan Pickens, point of
And-
I move to table this until we can have further discussion either at this convention or the next convention.
There's been a motion to table. Is there a second?
Second.
Second by Josh Flynn. Any discussion?
Mr. Chair.
Yes.
For the resolution to table, I think the main problem I'm seeing with this particular resolution is the fact that this is a top-down solution. There's no information about how, let's say, precinct conventions, county SD conventions could consider federal legislative priorities. I think this needs to take a bit more of a rational approach in terms of just kind of reviewing what can be done in the future when it comes to federal legislative priorities. So for those reasons, I would be in favor of tabling.
Thank you. Any other discussion? Seeing none, we'll move on to vote on the motion to table. On favor of the motion to table, please say aye. Aye. All opposed? The ayes have it. The amendment's tabled. And we have no other amendments submitted on Rule 34. Does anyone else have any amendments on Rule 34? Seeing none, if there's no objection, we'll move on to Rule 33. Hearing none, we are on Rule 33. We have no submitted amendments on Rule 33. Does anyone have an amendment on Rule 33? Seeing none, if there's no objection, we'll move on to Rule 31. Hearing no objection, we are on Rule 31. We have no submitted amendments to Rule 31. Is there any amendments to Rule 31? Hearing none, if there's no objection, we will move on to Rule 30. Hearing no objection, we are on Rule 30. There's no submitted amendments to Rule 30. Are there any proposed amendments to Rule 30?
Mr. Chairman.
Yes.
Robert Garay, SD6. I'd like to make an amendment to subsection F, Rule 30, to include after permanent nomination, comma, permanent legislative priorities.
Under what subsection?
Subsection F.
State the language again.
Yes. So after the word permanent nominations, we'll add a comma, and then the words permanent legislative priorities. No, that's just. I'll bring it up.
Second, Mr. Chairman. Hold on. Yeah, it's report of the legislative priorities. There is no permanent nomination. There is a temporary legislative. Is there a second? Second by Matt Patrick. Do you want to speak to your amendment?
Yes, thank you, Mr. Chairman. So this is actually a clause that Virgil Cruz submitted that he mentioned this morning when he gave his testimony. Basically, it's just a cleanup item just to ensure that the appointment of a permanent legislative priorities is in line with them giving a final report. So it's really just just a fix kind of a mistake, not really a mistake, but an omission, so that we can get a legislative priorities committee appointed.
Mr. Chair,
Thank you. Hang on. Who just,
David Westbrook, SD19.
Point of information, Mr. Chairman.
hold on, who?
I was going to suggest a friendly amendment to the gentleman.
Hold on, I heard over here first, point of information.
Point of information, Mr. Chairman. Craig Licardi, SD1. In D, there's report of the Rules Committee. That's where we go. We tell our SD. We've done the last 3 days. E, report of permanent organization.
Hold on.
This is Senate district.
This is Senate District.
Or state.
Yeah, this is for
Right.
county SD district
Correct.
conventions.
Correct. Where we go to our Senate districts and we give the report of what we've done here.
Not at the state convention. This is in March.
When you were
April.
elected as
Yeah,
state delegate.
Okay, my bad. I'm sorry.
no problem. Go ahead.
Thank you.
I was about to propose a friendly amendment to add the report of the Legislative Priorities Committee and adoption of the report as a bullet point.
So that's on H subsection.
It's already in there.
Is it?
In subsection H.
See it.
Any other discussion? Dan?
Yes, a lot of the smaller counties do not have permanent legislative priority committees, nor do they appoint or elect. So is that friendly amendment to me after the clause desired in parentheses or something like that? This is almost like a requirement that a lot of the smaller counties do not do this.
Thank you. Anyone
So
else?
as an amendment, I would like to put in parentheses after the report that you just had, which is gone now. Is it moved down? If desired, or something of
This
that
is not
form.
having to do with the report. The report is already in there under subsection H.
Not
It's only the
report, it was the legislative priorities on the line earlier. Has it been removed now or what?
No. The report of the Legislative Priorities Committee exists in the current language and is under subsection H. We're talking about the appointment of a permanent Legislative Priorities Committee in subsection F. That's what this amendment deals with.
Mr. Chairman,
Yeah.
Robert Gray, SD6. Point
Hold
of
on, hold on
information.
one second.
Yes, sir.
Talking about changes on the fly. I'm reading it one time.
Is your amendment to add if desired to the permanent legislative priorities committee under section F?
That's what I request, but I'm trying to figure out what I'm reading here versus there. Before
Read
it
up
was
here.
here, if it's gone now,
It's not gone. Read up here. The red language is all that's being added to the current rule under this amendment.
that's fine.
And if desired is your language.
That's fine, or something of that purpose. I don't know what sense if desired.
Got to decide. Is what you're going for applicable? Which, if applicable,
If applicable is fine. Whatever y'all want and whatever they will agree with. I don't know who was the one that submitted the actual amendment.
and are you proposing a friendly amendment or are you asking the author?
That's correct.
Okay.
So who proposed
That language you wish to propose, if applicable.
if applicable is fine.
Mr. Chairman.
Does the author accept that as a friendly amendment?
Mr. Chairman, before I answer, I have a point of information.
Yes, we state point of information.
Does the general rules explicitly say that the Legislative Priorities Committee is a required committee under SD county conventions?
It does at the moment, but did not before.
So
2024 subsection H was added, which makes it a requirement.
So I do not accept friendly amendment.
Can I propose it as an unfriendly amendment?
I can tell you this, the literature and the inside.
You want to propose it as an unfriendly amendment or no? Then we could debate it.
Just remove it and we'll work around it.
Okay. Back on discussion of the amendment. Any further discussion?
I'd like to speak in opposition.
Chris, go ahead.
My county, SD was very frustrated at the convention that being required to maintain an LP committee and a platform committee. And I was told by several individuals that they would prefer what my understanding is the old rule, which was basically that the Senate District Platform Committee may also handle the legislative priorities, and then, and making the legislative priorities committee optional. I believe this is an omission, but I would like to not have to clarify this when we go up one rule, because I would like to make LP an optional committee at the Senate District / county level.
Thank you. Any further discussion? Yes.
David Westbrook,
David.
SD19 in favor. My SD19, we had in Bear County anyway, because we're a multi-county. I don't know what happened in the other counties, but we had a resolutions committee and our LP committee were the same committee. They just did all the work. Warren Osterman is a beast in that regard. This needs to be there. I've been saying this since I was on the committee that created LP, and at the time I was we need to put this as talked if we're going to make the mandatory at the state, and it didn't do it then, but they now done it, and this needs to be done just to close the loop on the rules.
Thank you. Anyone else? Any discussion?
Yeah, Carmen Calderon, SD27, speaking against.
Okay, go ahead.
Speaking against for the same reasons that were brought up. I just think smaller counties and smaller SDs, you only have so many delegates and so many people to choose from to create these committees. And if a resolutions committee can handle both, let them do it. And the counties that have enough people or can't handle both under one committee, they can create a separate committee. So I think it should be left up to each SD/county convention.
Mr. Chairman.
Yes, who is that?
Robert Gray, SC6, just to respond in favor. So I think there's nothing in the rules that I'm aware of that that members who are appointed to the resolutions committee at SD County Convention Committee at conventions could also be members of the Legislative Priorities Committee. So I don't really understand the point you're making. If at this stage there's nothing in the rules today that say that more that one delegate can serve on multiple committees. This is actually language heard when the SD convention committee were being assembled during it was a Zoom call from the Republican Party of Texas, where there was sort of opposition about why do we have to have legislative priority committees. And obviously, if we're having a state legislative priorities committee, I do think it's reasonable, and it's already explicitly defined in the rules that there should be legislative priority committees. And obviously, if there are methods to work around that for smaller SD county conventions, I think that's perfectly allowed in the rules. So I think with that in mind, we should establish or at least codify that legislative priority committees should be a requirement.
Thank you. Anyone else? Seeing no further discussion, we'll move to a vote. All in favor of the amendment, please say aye.
Aye.
All opposed? The ayes have it. The motion passes. Do we have anything further on Rule 30? Justin?
No, not on 30, but on 29.
Okay. So if there's no objection, we'll move on from Rule 30 to Rule 29. Hearing none, we are now on Rule 29. Justin?
Mr. Chairman, I've already submitted a proposed amendment which mirrors the language that we add for the Legislative Priorities Committee at state, tying it to specific things. But before we do that, I would like to make an amendment to number 6 there for legislative priorities at the end. It says, in the discretion of legislative priorities at the end of that, number 6. In the discretion of the temporary chair, the Legislative Priorities Committee may be combined as one and the same with the Resolutions Committee.
I'll second that.
And I think that and then we'll get to the other amendment.
Can you dictate that again?
So at the end,
You didn't send that language, right?
yeah, in the discretion of the temporary chair, the Legislative Priorities Committee may be combined as one and the same with the Resolutions Committee. That may address, and that's my motion, and then I'll address it.
Okay, and there was a second by who?
Gene?
Gene. Second by Gene. Do you want to speak to your motion, Justin?
Very briefly, this was new. It kind of it created an entire new committee, and I think the Resolutions Committee, the people who are most interested in that, are also interested in legislative priorities. Interestingly, resolutions isn't here at state. You have platform and legislative priorities. So it makes sense if this is something that works for a particular SD or county to have this discretion. Of course, if delegates are outraged and furious, they can fire their temporary chair and get a new one the day of the convention if they want. But I think this gives flexibility for each temporary chair to do what's needed with what the resources and time and volunteers that they have in their particular locale.
Um, the chair has a question. Hold on. Josh, hold on. Chair wants to clarify, when you originally dictated your amendment, you said discretion of the chair, correct? Not in discretion. Say yes.
Yes, I think they
Thank
did.
you.
Now that I'm recalling, just give me a moment. It's at the
Any other discussion?
Mr. Chairman, Andy Eller, SD24. I do have an amendment. I think it's probably a friendly amendment. I would say temporary convention chairman because we use chairman throughout the rules. We don't use the word chair.
Oh, fine.
And we do want to clarify that it's the convention chairman because we use, when we're talking about who's setting these temporary things up, we always talk about the temporary convention chairman.
Cool.
Okay. Is that acceptable to the author?
Oh, yes. Yes, Mr. Chairman.
Thank you. By the way, just we are going to clean up the misplaced references to chair and chairman when we are cleaning up the rules. Gene.
Yeah, I'll speak in favor of this also because it's precisely how I ran my convention in March.
Mr. Chairman,
Thank you.
I'd like to speak in favor.
Go ahead.
This covers exactly the concern that's been brought up to me, and I appreciate you bringing the amendment. Thank you.
Thank you.
And Mr. Chairman, Robert Gray, SD6, also speaking in favor. Now that we've established that legislative priorities should be part of SD county conventions, this is a reasonable alternative, or at least a reasonable workaround, as I mentioned earlier in our previous argument. So for that, I do support it as well.
Thank you. Any other discussion? Hearing none, we'll proceed to a vote. All in favor of the amendment, please say aye.
Aye.
All opposed? Ayes have it. Motion passes.
Mr. Chairman.
Which were the same. Justin, go ahead.
Then I will propose and fit it in. Rachel, I think I emailed you the proposed language. Run 29. That's fine. Yeah. So that would be my motion related to that. We can bifurcate it. So that would be my motion related to that, to add each of which must be one and only one plank in the current platform.
Which one? The different. Okay. Wasn't that sorry. Okay, so the proposed amendment is to add the highlighted language, each of which must be one and only one plank in the current platform. Is there a second?
I'll second it. Robert Gray, SD6.
Second by Robert. Do you want to speak to your amendment, Justin?
Briefly, I think that we just adopted this language for the state legislative priorities committee. This, this is supposed to be a bottom up process. This gets us thinking at the SD level, specific legislative priorities to specific platforms that can then be forwarded to the state convention committee for consideration under the same lens that it needs to be tied to a platform. So I think this just kind of starts the process and gets it cleaner from the bottom as it moves up through the process to the state convention. So it's just supposed to be consistent throughout the various levels of conventions.
Thank you. Anyone else? Gene, go ahead.
I'd like to speak against the motion as presented.
He's against.
I understand what you're saying. It's what we put in place for the state level, but at the lower levels, we're looking for inputs, and I don't think any limitation ought to be placed on a concept that a county or senatorial district committee can provide.
Mr. Chairman, Daniel Hunt at ST3.
Go ahead, Daniel.
Speak against. This is actually the opposite of ground up. This is actually top down, telling the ground how to do something. I think we need to let each county or senatorial district convention figure out how they want to submit their legislative priorities, and when it gets to LD committee, they can clean it up.
Thank you. Anyone else?
David Westbrook, SD19, in favor.
Go ahead.
This isn't dictation. This is, we've already established, if we were dictating, we've already dictated. This is just making sure the pipe flows cleanly from the start to the finish.
Dictating.
Thank you. Anyone else? Okay, discussion's closed. We'll move to a vote. All in favor of the amendment, please say aye.
Aye.
All opposed?
No.
The ayes, please stand up.
Two, three, four, five,
Please stand up. And the noes, please stand up. Everybody who's no, stand up. 1, 2, 3. Any abstentions, please stand.
One abstention.
The vote is 14 to 14 with one abstention. The, well, it doesn't matter. The vote is 14 to 14. The motion fails.
In light of that, then I had the same suggestion for D3. So if that was which relates to the permanent convention chairs. So I have no further motions based on that vote.
Thank you.
Mr. Chairman.
Mr. Chairman,
Got, yes.
Robert Gray, SD6, I have a written motion to the secretary in regards to subsection B and D.
We got it.
Okay. And as the secretary is pulling up, this relates to the delegate, the minimum delegate thresholds.
Well, let her put up so we get a second.
Okay, no worries. No worries.
Doing both subsections B and D in one.
You said D and E in 20.
We're doing them both together, the changes to subsection B and D, which is fine.
Yes. Yes, that was the intention.
It's on 29B.
Okay.
Is that right?
Is that correct on B?
Yes.
Okay.
Katie Jackson, SD 18, second.
Hold on.
Oh.
I'll call for a second. Just a second. Is that correct on D?
Yes.
Thank you. Is there a second? Katie?
Second.
Katie Jackson, second. Do you want to speak to your motion?
Yes, Mr. Chairman, thank you. So actually, I'm speaking on personal experience with this one. So I'm from SD6, so we actually are a smaller SD compared to like SD7 for Grant or some of the others. So in our SD convention, basically what this refers to is that right now, let's say, so in 2026 we had 57 delegates. So basically, what that means is that for the composition of of committees, in terms of the number of delegates per committee, it requires a minimum of 5 members. So basically, with 6 committee, let's say if each committee was staffed individually and we have a combination between temporary legislators and resolutions, that would mean that a total of 30 delegates out of 57 would be needed in order to establish committees with a minimum of 5 members per committee. So basically, and in fact, just to give you experience, our temporary convention chair had to cold call every single delegate, including new ones, in order to ensure that a minimum of 5 delegates per committee was established. So basically, this particular amendment, it just raises the threshold from more than 50 to more than 75 to ensure that let's say in this case, if we were under these rules, then we'd be able to establish a minimum of 3 delegates per convention rather than 5. There's still there's nothing in the rules that just cannot have a minimum of more members of the committee, let's say 5 or more if the interest is there. But because of that minimum threshold, our temporary convention chair was very hamstrung when it came to the composition of the committees. So just by raising the threshold a little bit more to 75, I think this will definitely give our those convention chairs more flexibility.
Thank you. Anyone else?
Katie Jackson, SD 18 in support.
Are you for or against, Dan?
I have a point of information.
Yes.
I would like the determination whether the word delegates means true delegates that are there or true delegates that are allotted.
That are alive?
By the way, that makes a big difference. This year, our allotment was huge.
Delegates that are there or delegates that are alive?
Yeah, because you can have
As
an
opposed to delegates that are there and deceased?
allotted. You can have 100 allotted delegates. I'm still alive.
That's the Democrat Party that uses dead people.
It does make a big difference.
It sounds ridiculous.
We only vote for one guy.
It raises the threshold to allow before you get to the 5. That's all it does. Right, but the allotment comes towards the number of delegates that are exact. Right.
It should be allowed.
The allotment. So let's say I had 100.
It's the allotment.
Yeah. This is the allotment. Katie, go ahead.
All right, I'm in support.
Hang on a second. So this is the allotment based.
Hold on. Is it another point of information?
Just another point of information.
Okay, go ahead.
Is this the allotment? Are you sure, or is this the elected at precinct level to go to the county or state?
So Robert,
Robert will address the question.
so my understanding is that when that 57 number I came up with earlier, that is the elected number of delegates that were from the precinct convention going to the SD convention. So basically, the 57 is just those that were allowed to be that were of the available pool of delegates that we could pull into SD committees.
Yes. And the chair recognizes that's correct. Katie,
All right,
want to speak now?
being the small county chairman of my my county convention, we usually plan on 49 people being there. This time we had 60. I had to scramble to find 10 people to get on the committees who had no idea what they were doing. I just had to have a body on a committee. Raising this to 75 helps small counties tremendously. And I fully support it.
Thank you. Anyone else for or against? Seeing that, we'll close discussion. All in favor, please say aye.
Aye.
All opposed? The ayes have it. The motion passes. And then we have Gene Martin.
Mr. Chairman, Daniel Hunt, ST3.
Yes, do you have a motion or?
A motion.
We're going to do Gene and then we'll go over.
Yeah, I submitted a
Did you
change
submit it, Dan?
to
Is it
I will right now.
perfect? Gene, go ahead.
subsection C.
You submitted it, so we'll get it up on the board and then we'll call for a second after it's up.
And when I got the request to make this recommendation, I laughed. I didn't really see a need for it, but it was described to me that at least one chairman of a convention didn't understand that.
Hold on a second. We get it. Does that accurately reflect the 3 instances of printed?
Yes, sir.
Okay. Is there a second? Second by Matt Patrick. Please Go ahead, Gene, proceed.
Okay, this is to simply make it crystal clear that the copies of the reports are supposed to be hard copy printed paper, not anything else. And like I said, I was somewhat astounded that it was a request based on a real situation where the chairman of the convention thought that telling you that it was available online was adequate. That's it.
Thank you. Anyone else?
Mr. Chairman, Brandon Moore, SD 21.
Go ahead.
Whether it's a friendly amendment or just an amendment, I do have an idea for this one.
I don't know how you're going to amend printed.
Okay,
But
so
go ahead.
maybe it's just another amendment. Sorry. And my point to this one is, you may have conventions. We have counties that have conventions that have one or two people at them, and so it's ridiculous to have 5 printed copies. Require them to have 5 printed copies. Perhaps we set a threshold. Temporary chair, convention chairman of a convention with at least 10 delegates present.
Hold on.
Yeah, we'd have to do that in a separate
Okay.
amendment. Okay. Anyone else on this one?
Yes, Mr. Chairman, Craig Licardi, SD1. I'd like to make an amendment to the amendment.
Please state your amendment to the amendment.
After the word printed copies, in each of those 3 instances, I'd like to add per 50 seated delegates.
I'm laughing at the grumbling. Craig, we can take that up as an amendment after this because it's not really germane to this, which is
Okay.
just the amendments concerning whether or not these would be printed or electronic copies. It doesn't change the amount of copies available.
Okay.
We can do that right
Sure.
after if you want.
Absolutely.
So, yeah, that'd be out of order. So we're still on any for or against. We'll go vote on the amendment, which is, okay, only adding the word printed in 2 instances. 3 instances. So just the highlighted language. That's what this vote is on the amendment, on Gene's amendment, which is just the highlighted in yellow language. All in favor, please say aye. All opposed? The ayes have it. The motion passes. Now, if you or Brendan wants to make a motion.
I'd like to,
I want to give Brendan first because he
Okay.
did mention it first, and then I'll go over.
I'm going to make the motion to add that the
Brendan's going to go first because
Oh, I'm sorry.
he got shot down first, and then
Thank you, Mr. Chairman. Brandon Moore, SD 21. After the temporary convention chairman in the first line, add of a convention with at least 10 delegates present.
okay. Is there a second?
That makes sense. I'm good with that.
Second by Matt Patrick. Please speak to your amendment.
Just a threshold there. It provides at least 1 copy per 2 delegates, for that threshold. That way there's no limited waste, at least.
Thank you. Anyone else?
A quick point of information.
Dan, go ahead.
How in the world, when you're at a convention center and you're having your committee's report, how do you print them out at the convention center?
The chair is advised that a good way of making that point is by arguing. Anyone else? Hearing none, we'll move to a vote. All in favor of, and this is of a convention with at least 10 delegates present. All in favor of adding that language, please say aye.
Aye.
All opposed? Will the ayes please stand up? I don't. Josh is very loud. Listen, the motion passed. When you vote no, no one else. I can't hear.
Mr.
All
Chairman.
right, Craig.
Oh, it was me.
Oh, no, I was,
Yes.
do you have something other than a motion?
I have a motion.
Because I'm going to recognize Craig for his.
Oh.
Okay. So, Mr. Chairman, my motion is to add the five printed copies per 50 seated delegates who are present.
Is there a second?
Second.
Second by Randy. Do you speak motion?
Yes, thank you, Mr. Chairman. So the reason for that is a lot of times the resolutions committee and or legislative priorities committee, they do all the work in between the precinct convention and the county convention, and they produce a body of work. But it's really difficult for a lot of the delegates to, if they do get an electronic copy, to follow through what's going on a small telephone screen. And for those who didn't get an email with that and also didn't get paper copies in the building, nobody knows what's in the report. And so it's really difficult for the delegates to follow along with what's going on and to understand what the work product is because they don't have any access to it. And that happened pretty to a large degree in our county. So having enough paper copies for the delegates to be able to have something to look at during the convention, I think is a great idea. Thank you.
Thank you. Anyone else?
David Woodford, ST19.
Are you for or against, David?
Against.
You for or against? Okay, David, go ahead.
There's this thing called PowerPoint, right? Every single convention I've ever been to, every single platform plank has been on the screen on a PowerPoint so that everybody in the auditorium can see it and read it and understand what's going on. You don't need to have it printed, let alone 5 copies for 50 people. That's a lot of money for a lot of paper that's going to get thrown away. There's no call for this.
Thank you. No, go ahead.
Brenda Platt, precinct, DC, SD12. I'm speaking for the amendment. We're in a small county, Wise County, and our precinct convention and our county convention was very, very successful. We filled our delegates. We have the most delegates we've ever had coming to this convention. And we had a printer at our conventions, and we had information for all our delegates. They were very informed, and that's why they're all coming to this convention. It's very important to inform your delegates and be very professional at these conventions. We are Republicans, and we need to represent ourselves well. Thank you for that.
Mr. Chairman, I'd like to speak against the amendment, or
Who's talking right now?
I want to speak against the amendment.
Go ahead.
I don't think the language in here is necessary because there is nothing with the current language that precludes any county from printing as many copies as they would like.
Exactly.
Thank you. Anyone else?
Real quick, Mr. Chairman,
Yes.
Carmen Calderon, 27, I'm speaking against for the same reason. I think we're managing the county and SD conventions and parties way too much in some of these rules, and we really need to think about that. Just like the gentleman said, You can still do this, but we don't have to enforce it for every single SD convention across the state. So for that reason, I'm against this.
Anyone
Mr.
else?
Chairman?
Yes, correct.
So I'm totally familiar with PowerPoint. I've used it multiple times when I've chaired this committee and presented it. The problem is when the work of the PowerPoint, the file or the PDF isn't communicated to the delegates prior to the county convention. And then there's only a handful of copies for a couple hundred people. Nobody can see what's in it. And there's buried uh, resolutions inside of it that people aren't aware of that maybe are not as popular as they might be. And so the problem is it's a lack of communication. And so I'm just simply asking for a minimum amount of paper to be sitting there so people can see what's going on.
Mr. Chairman, speaking against, um, as a shareholder of Boise Cascade, I would favor this amendment. But as my position on rules, I would speak against it. I don't think we need to be using that much paper. It's very impractical. It's prejudicial against large SDs. If you have 500 delegates, that means you have to print out 50 copies of your rules and your platform or your resolutions and your OPs. That's a lot of paper. It's going to take a lot of time to print it out while you're trying to get through your convention quickly. You got to collate it, so either do it by hand or you're going to have a big printer that you bring with you. So I don't think it's practical for a big county. And there's nothing, as the gentleman said, there's nothing that would prevent you from doing that if you choose to, but we shouldn't make it mandatory.
Thank you. Any other discussion?
Mr. Chairman, I just want to say one thing as a point of information.
I do. It's going to be a point of information.
Okay.
Do it.
I have run so many SEs and county conventions. This is simple, right? You have your meetings ahead of time of your committees, but you also have the committee meetings the day of the convention. The form comes out, it's either in Word or PDF. You mail it to all of the potential delegates. At the convention, you also update whether it's the platform or legislative priorities. You update it, you turn around and you display it on a screen, you pass it, and then you mail it out to everybody, email. There's no reason for mandated paper copies. That causes all sort of logistical failure. It really does. And personally, I just assume we reconsider the printed and get rid of that.
Thank you. I noted your point of information is speaking against. Anyone else? We'll move. Are you wanting to speak, Gene?
Everything he said.
I like that speech. Short to the point. Um,
Mr. Chair, Daniel Hunt, SD3.
Daniel, go ahead.
Speaking in favor.
Okay.
It was mentioned earlier they can show it on a screen or all these other things. Some counties can't afford a screen or a projector or whatever. Some counties have a county chair who is not friendly to delegates and won't provide information and keeps it hidden so that the delegates won't know what they're voting on. This would prevent that. This would make sure that all delegates at every convention know what is being considered, what's being voted on. So I'm in favor.
Thank you. Anyone else? Seeing no other discussion, we'll now vote on the highlighted language. All in favor of the amendment, please say aye.
Aye.
All opposed? The nays have it. The motion fails. Daniel.
Mr. Chairman, Daniel Hunt, SD3. I have a amendment to Part D. I've emailed it to Secretary. It would change the next to last sentence there if the convention has more than, and it would make it read, if the convention has 75 or fewer delegates, then each committee must be composed of at least 3 delegates. And I can speak to that when you're ready.
Have it up there. that correct? Okay.
This is almost like somewhere.
That's it.
We're not taking public testimony right now.
This is the entire rules
We're not taking testimony right now. We're taking testimony between 10 and 11 and 3 and 4. The sign-up sheets were here and they were unfilled.
Told him to come.
clarification question.
You're not recognized to speak. We're having a committee meeting right now. Please be seated.
We don't get differential treatment for a
Please be seated.
We've been working in
Please be seated, sir.
May I just respectfully say,
Now,
we gave you
please be seated, Cindy.
members.
Cindy, be seated. I'm going to call security. Be seated. We have sign up for public testimony between 10 and 11 and between 3 and 4. The sign up sheet was not filled. Don't come storming in here now, interrupting my meeting. Please be seated. You have it up there? Daniel,
Thank you.
does that accurately reflect your amendment?
Yes, it does, Mr. Chair.
Thank you. Is there a second?
Give me a second, somebody.
David Westbrook, SU19.
Thank you.
Second.
Well, I can explain if I.
Second, Parker, SD4.
Second by Parker. Please lay out your amendment.
Thank you. Mr. Chairman, this year Henderson County had 33 delegates at our convention. We were barely over the 25 minimum. This, what's a committee supposed to do, or a convention supposed to do if have somewhere between 0 and 25? This simply makes it 75 or fewer. And so that's the purpose of this. And we're not a small county. We just ended up having very few people attend our county convention this year. So I'm sure there are some even smaller counties that could easily have less than 25. So this would just close that gap.
Thank you. Anyone else speaking for or against?
Mr. Chairman, point of inquiry, NDL or SD25 or SD24, excuse me.
What is the question?
Well, if we're changing it here, do we not need to change it in B as well? Because you could literally have a temporary committee that would have 5 members because it would fall between the numbers, and then you'd wind up having a permanent committee that would have 3.
If that's a friendly amendment, I will accept it.
Oh, I'm not making an amendment. I was just a point of inquiry.
No, it's just a point of inquiry.
Okay.
Did we consider this before?
Yeah, we just did this.
You know what might help if Robert
Yes.
speaks
Thank
and
you.
speaks to how this affects what we had
Yes.
already passed.
So first off,
Thank you.
subsection B
Is
relates.
this for or against? Should I note it?
I will say for.
Okay.
So subsection B, which well, at first let me speak to subsection D. Subsection D refers to the permanent committee. SD county conventions. Subsection B refers to the temporary committee
SD county conventions. So anything we change in terms of delegate allocation and committees, then we're going to have to make that same change between subsection D and subsection B. Now, in this particular, I think there was a question about whether this was already considered. Now, the amendment that I had posted before that was passed was talking about a threshold between 25 and 75, where basically within that margin, then there would be a minimum of 3 delegates per per committee. So I understand what his resolution is doing is making sure that that threshold of 25 to 75 just means between basically not all under 75. So the idea being is that let's say if you had delegations of 10 or 15 or 20, then this particular one will now, this amendment that he's posting will now ensure that all committees or all state county conventions under 75 delegates will be at least 3 delegates instead of 5, or at least as the minimum. Doesn't mean you can't have 5, but in terms of the minimum threshold of committees, the size of those committees, it can be 3.
Right. Three on delegates and the permanent they don't show up. Seated that show up. So I guess that's why it's different for me too. So they don't have to vote. Or two different. Jocelyn 15. So what I'm understanding is that the temporary will be the 75 threshold because of we've got delegates, and then the permanent would be the 75 because we have seated delegates, right? So that would change if we don't have seated delegates as many. So that's the difference.
Yes.
Okay.
Chairman, I have a question for the author.
Go ahead.
Not to take John Beckmeyer as a punching bag for every small county, but he is a one-man county convention theoretically at the moment. Does this, removing this 0 to 25, does that mean he has to sit on every committee at his, or?
Hey, you guys aren't going to let the priority.
Sir, sit down or you'll be removed now.
I'm
Sit down.
I'm talking about the priority.
Sit down. You're not recognized.
Well,
You're out of order. Sit down.
some people who recognize.
Sit down. Please proceed.
How do extremely small counties, which we do have, handle 3 per? Does not the 0 to 25 allow them to have the flexibility to be like we have 2-man committees or one pops the committee?
I suppose if you had a one-person county convention, he's going to be everything. I guess that's true, but I don't.
I guess what I'm telling you is there any reason we can't maintain the 0 to 25 in your opinion?
Well, in that case, I think we would have to put in there something that says under 25 because this doesn't address 0 to 25 at all.
Okay.
So I could turn a minute motion. If
I guess, is there something wrong with the current language that we need to push the threshold this low?
Well, because it doesn't specify what you do under 25 at all.
Gotcha.
I suppose the other option is we could say if you have less than 25, you have discretion at your committee size or something like that.
We do not. Not on this rule. Anyone else for or against? Okay.
Mr. Chairman, I think there might be a point of information.
Please state your point of information.
So on subsection D for the way I'm seeing this right now, and correct me if I'm wrong, it basically says that this is I'm seeing it. So it says at least how it was previously. If the convention has more than 75 or fewer but less than, actually, no, scratch that.
More
I
than 25
apologize.
if you were
We'll
75.
consider this amendment first.
Any other for or against? Seeing none, discussion's closed. We will now vote. All in favor of the amendment, say aye. All opposed?
Nay.
Nay have it, the motion fails.
Mr. Chairman, point of information, Robert
Yes,
Krasinski
please state
6.
your point of information.
So on the amendment that I had previously had made up, because I wanted to make sure the motion was taken up from him before I mentioned it to you, Mr. Chairman. So according to the current version of subsection D, I would imagine this also applies to B2. Basically, the way I read it is that basically, when it comes to that 25 to 75 threshold, is that the way I read it today, and it might be just a miscommunication between me and the secretary. It basically would say if it's more than 25 and then at least 75, then basically you would have committees of between 5 and 15 delegates. I believe that should say less than 75. So that threshold we talked about earlier, about 25 to 75, it should be more than 25, but less than 75. That second part of subsection D.
Entities for 10 minutes until 8 o'clock. Take a bathroom break if you want. I would invite Daniel and Robert up here. Yeah, I think we're trying to sort it out. Take a bathroom break.
Clear now.
That's the problem. Really? Did you get it all? I don't know. One line. I think I'm gonna make them work.
Yeah.
So we don't have an amendment. Okay.
Chair has discretion.
Everyone, please find your seats. We'll call the meeting to order.
Yeah.
Please find your seats. Or rules committee. Thank you. Call the meeting to order. My understanding is that the motion was withdrawn, correct?
Yes.
Motion's withdrawn. Is there any other motions on, are we on 30? Any other motions on Rule 29?
Mr. Chairman, Daniel Hunt, SD3. I do have one that I'm typing up right now to send to Rachel. On, is that 29 that we're on? Yeah.
Is it long or is it one you
It's
can
one
recite?
sentence.
Okay, why don't you recite the sentence?
You want me to
Can you
just
put it up
recite it? Okay.
Where is it?
It would be B, just before the last sentence, the committee and their duties shall be as follows. And it would read, the convention has, well, hold on, let me make sure I get this right. If the convention has less than 25 delegates, then the county or Senate district chair has discretion as to committee size.
Thank you. Does that accurately state your amendment?
Yes.
Is there a second? Second by Brenda. Would you like to speak to your amendment?
This clarifies what we do if we have less than 25 delegates as county to Senate district convention.
Thank you. Anyone else?
Mr. Chairman, point of inquiry, Andy LRSD
State your
24.
inquiry.
Again, this is the same question I had before. If we're doing something in D, do we not need to do it in B? D is permanent, B is temporary.
Let's see if it happens in D first, and then we can make conforming changes. Gene, go ahead.
Yeah, I'd like to make a friendly amendment to make it read 25 approved delegates or elected delegates.
Seated?
As opposed to voting strength.
I mean, seated delegates?
Seated's good.
Elected delegates.
And you'll,
I accept that as friendly.
okay, it's accepted. Any other discussion? Data recognized for anything but a point of information.
As crazy as it is, I would like to speak against this.
Okay.
And the reason why is you really don't want a chair who may be rogue, who has now decided that all I need is one person on each of these committees and it's my person. They can make decisions left and right on stuff that you may not like specifically. That's the reason there's a 3 is a minimum. You don't want to go down to 1 or whatever, which this allows them to do. So I'm against this amendment.
Mr. Chair, may I respond?
Yes.
Well, the way it is currently, there is no direction as to what happens if it's less than 25. That's the problem. We got to do something to clarify what happens if you have less than 25 seated delegates.
Anyone else?
I'd like to speak against the current amendment
Go ahead.
and pretty much confirm what the last community member stated. I agree that there should be at least 3 people on a committee, irregardless. And if you got 25 people, you can find 9 people out of the 25 to sit on 3 committees. So, but you can't run a committee with 1 person on each committee. So I would put at least a minimum of 3 on each committee.
Sure.
Thank you.
May I respond?
Yes.
I tried that with my previous amendment and y'all voted it down. So,
Mr. Chairman,
Speaking.
Pat Patrick's SD 16.
Or against?
Against. If Mr. Hunt's objection that we don't have anything in the rules currently on how to handle situations where we have less than 25, then why not just eliminate the line where it says 25 but less than 50 so that anything less than 50 would apply? That would be the simplest, cleanest amendment you could make instead of trying to construct something separate for under 25.
Anyone else want to speak for or against?
I would like to speak for David Westbrook SD 19.
Please go ahead.
Um, this, it, we don't have anything in our rules. That means it would necessarily default to Roberts if we don't have anything. But if we go ahead and just put this in, then it's not an issue. And really, you're talking about less than 25 delegates. If you've got less than 25 delegates, you're going to probably have a chair do basically whatever they want anyway. So,
Yep, Mr. Chairman.
Thank you.
Robert Gray, SD6, speaking in favor. Obviously, with the previous amendments, there is a tier system that is being worked on. Obviously, you have, what we're talking about in this amendment is the smallest, SD or counties. And I think we've already agreed to what sort of the mid-size and large county should be. So I think we just want to make sure that there is something in the rules so that the permanent convention chair and then maybe later on the temporary convention chair can make sure that he knows what they can do when it comes to those delegate sizes.
Thank you. Is there any other discussion?
Mr. Chairman, Brandon Moore, SD 21, point of information.
Yeah, please state your point of information.
I am in Travis SD 21. We have very, very small conventions, about 8, 10 people maybe. We met as a committee of the whole. Would this preclude us from meeting as a committee of the whole? Is the chair advised?
no.
It would not.
Nope.
Thank you.
There's no other further discussion. We'll move to vote. All in favor of the amendment, please say aye.
Aye.
All opposed?
Hey.
Will the ayes please stand up?
What is that?
Please sit down. The ayes have it. The motion passes.
Mr. Chairman,
Yes.
Robert Gray, SD6. I'd like to make a motion to include that same sentence that we just passed on subsection B.
Okay.
Second. Daniel Hunt.
Been a motion. It's been seconded. My understanding is this is a conforming change.
Yes, sir.
Can we do a conforming change without objection?
Mr. Chairman,
Yes.
I hate to do this to you, but there are no seated delegates in a temporary committee.
Yeah, we'd have to remove the word
There's
seated.
no seated delegates
We'd
in a
have to remove
temporary
the word
committee.
seated.
Mr. Chairman,
Yeah.
since it was seconded, I'd like to make an amendment to remove the word seated.
Okay.
And I'll second that change.
Please remove the word seated.
Can he do a friendly amendment? That way we wouldn't have to vote on that?
Well, no, we don't need a friendly amendment. We don't need it. It was just amendment to remove the word seated.
Okay. Does that reflect your amendment?
Yes.
Okay. Can we proceed to vote? Okay. All in favor of the amendment, say aye.
Aye.
All opposed? The ayes have it. The motion passes. I believe that's all we have on Rule 29.
Mr. Chairman, I do have a written motion submitted to the secretary, but on subsection D, line 3, however, in light of time, I will withdraw that motion from consideration.
Mr. Chairman, Brandon Moore, SD 21, point of information.
If there's, listen, are you,
I don't want to.
you're not going to get a motion for that.
So, Mr. Chairman, point of information, I made a written motion to the secretary regarding another change
Okay.
on subsection D, line 3. However, I would like to withdraw that motion.
Okay. If there's no other motions on Rule 29, hearing none, if there's no objection, we will move on to Rule 28. Hearing none, we're on Rule 28.
Make a motion.
If there's no objection, I would like to grant Cindy Castilla 3 minutes to speak. Hearing none, go ahead, Cindy.
Okay, thank you, Chair Rinaldi and committee. I'm speaking for the legislative priority committees, and I feel like everybody who is in the room to testify with us. We were kind of shocked when we got word about Rule 34, and I think it's Section C, but I have not, I've seen it, but in the past, committees impacted have been appraised that there's a big change coming. So we were caught off guard. Apologize for the way we came in, but we felt like we had to speak up. So thank you for this opportunity. I value our platform. When legislative priorities started, I had a little concern, honestly. What are these going to do? But what I have found, being in the Capitol most every day of a session for several years, at least three sessions, and really more, that legislative priorities are moving the needle of items on our platform. They're moving the needle because the party is actually taking responsibility for pushing the things that the people who come to our convention from all across Texas are asking to get pushed. Our platform is long. I like it. I think it's good. I don't like two planks, Matt knows. But I've seen the needle move. In every session, it's more because our party is actually asking for better language, asking to match the platform. Some of our reps, have never read our platform. Some people get elected to office who've never come to a convention and done this work. So the legislative priorities are getting some push, and we appreciate that. People get a voice on the Legislative Priorities Committee. It gets them another chance to testify. We live in a fast moving world, and issues change quickly. AI has come out of the blue. Sharia's been here, but it's really growing, and people are seeing and feeling the impact of it. That cannot get fixed with one plank. Either can elections. Either can natural resources, either can our grid. There are multiple facets of a lot of issues that mean a lot to the people that come to our convention and that are the feet on the ground for getting people elected and trying to move issues. So we ask you if you would reconsider this. We think it was short-sighted. I understand if you really like the platform, but if you do, you want to support it in a way that's actually working. And this is working really well. So I'm thinking even other issues, protect kids, education, the grid includes securing from people, but it also now includes batteries to deal with solar. We've got federal overreach. That's not one plank. We've got Texas state overreach. It's not one plank. So I believe that the legislative priorities is also a step, like it's a first step for a lot of our activists. They come down to make a difference there. As they get more involved and deeper in and understand issues, they come into the platform committee and they start to talk to that group. This is how we get people involved in what's going on in our state, in our nation. Thank you for your time. If you have any questions, let me know. I'm sure there are things I didn't cover, but this is why. Oh, I also wondered, how many of you ask your delegates from your district what they think of this rule? Because I think if I mean, I feel like this will get bashed on the floor if it's not removed. Thank you.
Thank you. And just to remind, actually, I think I misstated because we had the 10 to we had public testimony from 10 to 11 these past couple days. Tomorrow, the public testimony time is going to be 11 to 12 and 3 to 4. However, you can sign up starting in the morning. We can put them out like 8:30.
Okay. Thank you for that. You did tell me 11, so thanks.
Yeah, I told you 11. I think I said before 10, so I wanted to make sure that was corrected.
Okay, thank you.
Okay?
We appreciate.
Thank you. And by the way, Cindy, in the future, just come by, even if you have the whole committee with you, and just run around and hand me a note, and I'd be happy to accommodate you.
I told you I got lost in the room next time.
No worries. I'm just letting you know. Thank you. Appreciate it. Okay, we are on Rule
Make
20.
a motion to reconsider that rule.
Which rule?
She just spoke of 34.
Do it now.
I would recommend, um, just, I would recommend doing it after morning testimony, perhaps. I have a feeling that many of them are going to testify, and we do have some time to do this tomorrow, and we'll make sure we have time for it.
We have other rules that are important.
Yes. You can make the motion now. I would just recommend you do it tomorrow after you hear more testimony. But
Withdraw my motion.
did you vote for or against the motion, the rule?
I don't remember.
Okay. Yes, Susan. We are aware of the SREC meeting from 3 to 4:30. Yes, and then a couple people will be absent. Absolutely. When I say public testimony, I meant after the morning public testimony time. But you can move to take it up whenever you want. I'm just trying to put it at a point where we can meaningfully discuss it. Anyone on Rule 28? Hearing none, there's no objection. We'll move to Rule 27. No. Yeah, just 27. Moving on to Rule 27. No, not 27A, that's permanent. We're going on to Rule 27. Any amendments to Rule 27? Seeing none, there's no objection. We'll move to Rule 26. Is there any amendments to Rule 26? Seeing none, if there's no objection, we'll move to Rule 25. Hearing none, we are on Rule 25. Any amendments to Rule 25? Hearing none, if there's no objection, we'll move to Rule 24. Hearing no objection, we are on Rule 24. Are there any proposed amendments to Rule 24? Hearing none, if there's no objection, we'll move to Rule 23A.
Mr. Chairman,
Oh.
Grant Dunwoody, SD7.
Yes.
I move to amend 23A, paragraph
Hold
2.
on 1 second before I go. I'm not on Rule 23A. There's no objection. We'll move to Rule 23A.
Oh, I thought you said we were.
Hearing none on Rule 23A. Do we have any motions? Go ahead.
We do. Move to amend paragraph 2 of 23A to incorporate the language proposed by Mark Ramsey. He also had emailed, I believe, Rachel and the rest of the committee the language that he had in his various proposals. But this one, with respect to 23A, paragraph 2A rather, makes a, I'm not going to read it out, but I don't know if you have it, and you can be able to copy paste. Okay. And Rachel, I did confirm in his handout, he has a dot, dot, dot after senatorial district in 2A, what ends up being 2A. Basically, the rest of that paragraph gets removed down to the chart, including the chart, and then 2B basically replaces the chart.
Okay, what do we got? Are you typing it up?
I think you're making the changes to 1. Okay, there you go. Perfect. Okay, sorry.
You got it yet?
It's not an exact number because they have the total limit, so sometimes it it's just like I don't know why they have it all. Yeah, that's why I understand.
Paragraph 2 turns into
I'm with you. It doesn't make sense to keep this and have this, right? Because it's not going to necessarily. See here.
Change it to 2, this is the 1 to 2. So should it say should entitled to elect at least 2 and then this chart that's scratch. Make sure you have to change that to 2 down to
The check is signed off.
23 hours. It may be in speech. 23A number 2 round. Yes, 23A too.
There's 2 changes, one in subsection A2,
Oh,
2 delegates and 2 alternates instead of 1 delegate, 1 alternate. And secondly, striking B and replacing it with the underlying language. Would you like to, first of all, is there a second?
Anybody? Guess not.
Going once, going twice. Motion fails for lack of a second. Okay. Any other motions in Rule 23A? Yes, Katie. Got one? Think you submitted to the secretary?
Yes, I do. I already submitted it to the secretary. And it is, hang on. The second paragraph in 23A, under point A, I do believe. Okay. The number of county or senatorial district convention shall be entitled to 1 delegate, 1 alternate. Right now it's set at 300 votes. If we set that to 500 votes, we can have our the second.
Hold on 1 second.
Sure.
Let's just get the language up on the screen before. I gotta get the language up on the screen. We gotta do a second and then I'll let you speak.
We're good. I'm sorry.
No problem.
this one. Yeah, it says 2 days. Yeah, I see what he's saying. You didn't get a second though. Right. Kind of looks at it. Move to
Katie, can you come over here and
Of course.
sure we got this correct?
Okay, I have it here. I'm sorry.
Is that correct?
Yeah, it's what you have here. Okay, so, because there's no. Well,
I think he's just trying to make the says one here.
delegate.
The chart says two. He's trying to make a match.
Is it in any of the two paragraphs she's amending? Okay. And that's fine.
And then,
Provided that near some television should try to like at least delegates alternates. So it's already in the pool.
You can do it as one motion.
It didn't kind of harmonize that first sentence. So
I'm asking her. I think it works.
See when people go together.
Yeah. You can do it as one.
And then they see the chart, they're gonna be going both ways.
Okay, the proposed amendment is to add, to change the ratio, change the 300 to 500 votes in subsection 2 and subsection 3.
that's what this is.
And then in subsection 3, changing the 7,500 to 4,000 and the 9,000 to 5,000. Is there a second? Going once, going twice.
Mr. Chairman,
Yes.
Robert Garay, SD6, I'll second it.
Okay. Motion's been seconded. Do you want to speak to your motion?
I would love to speak to my motion, Mr. Chair. We know that 2 years ago, we did not make fundraising goal in order to afford the convention. And we're in the same boat this year. I've seen some emails from people that know. And also talked to Abraham George about this. Right now, he has to negotiate everything for 9,000 delegates, whether we have them or not. It's getting expensive. If we essentially cut that in half, a couple of things can happen. One, we'll pay less. The party will pay less. Two, we can go to other places like Corpus Christi, because then I don't have to drive, which is cool. So what this will do is it decreases our number of delegates. It gives us more places to go. More bidding can happen. It makes it a little more affordable. And I feel it'll have it'll dampen a little bit of the convention chaos. Just my thought. No proof on that. That's all I've got to say.
Thank you. Anyone else want to speak for or against?
On against.
We have, go ahead, Dan.
Yeah, I want to speak against this. That was part of the original group years ago, and we said it at 300, and of course, we've been tweaking that number every couple of years to keep the ratio between 75 and 9. If we're a party of the grassroots and now we're going to turn around and reduce the effective size of the convention, you're reducing the ability to get more of the grassroots at the convention. I see no reason to change the number. Leave it at 300, or it may drift up to 376 or whatever that is. It's easy to compute. You get a spreadsheet, you put the ratio on the top from what the SREC tells you that you're going to need, and you produce your list. We do not want to shrink the size of the convention.
Thank you. Go ahead, Randy.
Randy Dunning, SD2. I agree with Dan.
yes, you can reduce the size of the convention and reduce the chaos. The chaos. The chaos we're talking about that we wouldn't have at any convention. I mean, that's the assumption that if we double the size of the convention, it gets more chaotic. I don't believe that. I don't see that. I haven't seen that since I've been coming in 1988. Now, what we do have is we have these occasional large influxes of people. Robertson's Raiders in 1988, I know I was one of them. The Ron Paul people that came in the early 2000s. You get these, and even before my time, there was the Reagan people that came in, and all those groups came in, plugged in, and have enriched the party. And having a large convention makes that possible. So I'm going to oppose this motion.
Mr. Chairman, I'd like to speak in opposition.
Who's this?
Dave Wilson, SD11.
Okay, go ahead, Dave.
Um, I too am rising to speak against this because the advantage of having a large convention, which I think is extremely important, is to expand our party, get more people involved, and the number of people that come to our convention is that. The whole idea about conventions getting out of hand has to do with inexperienced delegates or, quite frankly, chairmen that don't keep order in the meeting. Now, with that said, my focus and what I've been told by my constituents is we need to get more Republicans signed up so that we have the numbers to win and keep Texas red. Having a large convention accomplishes that. Thank you.
Mr. Chairman, point of information, Carmen
Please state
Calderon,
your point
SD
of
27.
information.
Is the chair advised on what the average attendance is for previous conventions?
Sort of.
Do we ever
But I
hit
don't
9?
remember, and if I say it, then everyone's going to say I was wrong. So it's generally quite a bit. I know between delegates, alternates, and exhibitors, we had as many as 50,000 people. As far as delegates and alternates, I believe one of my years we had at least 7,500. It's definitely exceeding these amounts.
Okay, thank you.
Mr. Chairman, Andy Eller, SD24. I'd like to speak against.
Go ahead, briefly.
Okay, just real quick. The 2022 gubernatorial election, Greg Abbott received 4,437,000 votes. If we divide that by 300, that's over 14,000 delegates that we would have been allotted. That's why it was ratioed down to the maximum of 9,000 for this convention. If we change it to 500, it would come down to 8,874. And again, we'd be limiting it to below that, I believe it was 7,000 number, 5,000. We're still going to be limiting it. I think Mr. Ramsey's calls to say we wanted to stop having to do these weird calculations. He just wanted to divide it by a number. And so we're going to wind up be eliminating it ourselves. And every 2 years, we're going to have to change it, or every 4 years, we're going to have to change this rule to allow us to stay under that 9,000 number. Plus, I believe, you know, we keep saying we're the grassroots party. Well, the more grassroots are involved, the better it is. Even if we don't get all 9,000 people, we're still allotting those 9,000 people. So I'm just speaking against it, just because the numbers say we can get those numbers. Thanks.
Thank you. Seeing no other discussion, we're going to proceed to vote. All in favor of the amendment, please say aye. All opposed?
No.
The nays have it. The motion fails. And I remind people, if you're not going to vote for a motion, don't second it. It'll save time. Anyone else on Rule 23A?
I have one.
Ian?
SD30. It's similar, but for a different reason. Um, the change that I'm proposing is in 23A, excuse me, 23A B.
23B, you mean? 23AB.
23A, the rule, so paragraph B.
Is it Bravo?
Yes, Bravo.
Yeah.
And that paragraph allows a county or senatorial district executive committee to modify the ratio from 1 in 25 up to 1 in 40. And I am requesting that we change that upper limit to 1 in 90.
Is that your amendment as stated on the board? On the screen?
I think that, well, first paragraph, is that of a 9 and a 0? I guess that's correct. Yes. Thank you.
Is there a, yeah. Is there a second?
Please.
Hearing no second, the motion fails. Any other amendments on 23A? Hearing none, there's no objection. We will move to rule number 23. Hearing no objection, we're now on rule 23. Are there any amendments to rule 23? Hearing none, we'll move on to rule 22 if there's no objection. Hearing no objection, we're now on rule 22. Are there any amendments to rule 22? Seeing none, if there's no objection, we'll move on to rule 21.
Mr. Chairman,
Well, we'll move on to rule 20, and if there's no objection, we would include if anyone wants to add to 1A, for example. Hearing no objection, we'll move on to rule 21.
okay, Mr. Chairman, I do have a motion on Rule 21.
Please state your motion.
What we'd like to do is, and this is based on Virgil's information. In fact, I'm the one who actually gave him this. Excuse me, I'm on the wrong one. I should have taken it up under the other one. So you'll have to forgive me. Actually, let me make sure this is going to be right. Just give me just a second here. Okay. I'd like to flip G and F, where G resolutions come before the election of delegates and alternates. So just flip those two bullet points.
Second.
A motion and a second. I'd like to speak to.
Yes, this has come up in a couple of precinct conventions that I've seen, and it actually has happened in the county SD conventions. A lot of times, what happens in the precinct conventions is folks will show up, they'll claim they'll be grassroots, they'll claim they'll be Republicans. They voted in the Republican primary, but they show up to the precinct conventions and they'll sign up to be a delegate to the county or senatorial district convention. So they sign up, and then we get to the resolutions portion of that precinct convention, and they'll present some of the most awful resolutions you've ever seen that are not conservative, grassroots in any way. Or when a conservative or a grassroots person will actually present a resolution, they'll vote against them. And now it's too late because you've already voted them to be a delegate to the county or senatorial district convention. By flipping the script here, what that allows the precinct to do is look at it and go, well, obviously that person we do not want in our county or senatorial district convention. And it helps us, keep our party the way we want it.
Mr. Chairman, Robert
Yes.
Gray, SD6. I'm in favor of the motion. So speaking in favor, I've actually seen a couple of examples in previous conventions where once the once the election is in place, the individuals in the precinct convention will leave. And I think the intention of this amendment, which I assume is the correct one, is so that we want participation throughout the precinct convention. So we want to make sure that, for the resolution period, if we do flip it, that these individuals who would like to go to SD county convention stay through the resolutions period, and absent anything in terms of, let's say if they present a resolution, let's say it's a bad one, but in either case, I want to make sure that we do ensure that the people who stay for the entire event, including resolutions, are then eligible to be considered, or at least will be make it more likely that they are considered.
Thank you.
Mr. Chairman, Daniel Hunt, SD3.
Go ahead.
The example that Mr. Eller gave actually occurred at our Henderson County at a precinct convention this year, and so I think this is a great amendment, and I will pass along to Mr. Eller that if you can remember the word and say it on the record that verbally used to describe those crazy things, then I'll definitely vote for his amendment.
Go ahead, Andy.
I am so sorry. I do not remember it.
I can't remember what was it.
Mr. Chairman,
If Dan would like to do
Wackadoodle.
if
Yes.
Dan wants to do
Wackadoodle. There you
request
go. Thank you.
information,
Thank you.
Is there anybody against?
Point of information, real quick. Why did we not?
No, 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 no.
Why did we not make?
I can't hear. Is there anybody
Why did we
against?
not make
First of
the
all,
change?
Mr. Chairman,
hold on. I just want to know if there's anybody who wants to speak against. Okay.
Mr.
Are
Chairman,
you speaking against or? I mean, because I am going to take.
I'd like to offer a friendly amendment.
Okay. First, let me take Dan. Go ahead.
So real quick, why do we not flip the order at the senatorial or county conventions to be the same?
I would agree.
I am all for what he says. I've seen this happen a lot. It's just an informative deal. Maybe we can handle that tomorrow.
I mean, you can ask the author as to why, but I do know that some logistically you have to work on both at the same time. Chuck, go ahead.
Yes, sir. Thank you, Mr. Chairman. Chuck Burnett, SD20. I'd like to, the first sentence says the agenda for each precinct convention shall include the following order of business. I'd like to add the words in the order listed. And that concludes my proposal.
Okay, this is a proposed amendment, which is any order listed.
Would you like that a friendly amendment?
Actually, the amendment wouldn't even be needed.
That's what it was. Okay, I will accept that amendment. So they have to do it in the order and they can't decide to move it.
Is this amendment acceptable to the author?
Yes, sir, it is.
Okay.
And then, Mr. Chairman, can I just speak real quickly to why it wasn't done at the county SD conventions? I do realize that now. It's because the nominations report comes after the resolutions committee report.
Thank you. Is there anybody speaking against? Seeing none, no more discussion. We'll move to vote. All in favor of the amendment, please say aye.
Aye.
All opposed? The ayes have it. The motion passes. Do we have any other amendments on Rule 21? Seeing none, if there's no objection, we will move to Rule 20. Hearing no objection, we are now on Rule 20. Are there any amendments to Rule 20? Hearing none, if there's no objection, we'll move on to Rule 19. If you'll hold on for 1 second. David, can you please approach? Or something permanent state. Okay, Rule 19 is a permanent state executive committee rule, not subject to amendments, so there's no objection. We'll move on to Rule 18A. Here none, we are now on Rule 18A. Are there any amendments to Rule 18A? Seeing none, if there's no objection, we'll move on to Rule 18. Any amendments to Rule 18? Seeing none, if there's no objection, we'll move on to Rule 17. Any amendments on Rule 17? Seeing none, if there's no objection, we'll move on to Rule 16. Are there any amendments to Rule 16? Seeing none, if there's no objection, we'll move on to Rule 15A. Any amendments to Rule 15A? Seeing none, if there's no objection, we'll move on to Rule 15. Any amendments to Rule 15? Seeing none, if there's no objection, we'll move on to Rule 14.
Mr. Chairman, Brendan Morris, sorry.
Go ahead, Brandon.
It's going to be on Rule 14. I don't think we're there yet. Is that right?
Oh, we're there.
Okay. And Rule 14, I would like to propose, and I did send this to the secretary about an hour ago, maybe. 14B, strike the word may and replace it with shall. It's the seventh word in that sentence. And at the end of the sentence, add, and every reasonable effort must be made to preserve such recordings in perpetuity.
Is there a second?
Katie Jackson,
Second.
18 seconds.
Second by Katie. You want to speak to your motion?
Yes, Mr. Chairman. Currently, 14B makes video recording or live streaming of our general sessions and meetings of any committee or of the state convention as an option, a may. I think that should be shall. We certainly have those technological capabilities now, and we do it all the time. And it says whether it be in temporary or permanent organization, and then at the end, adding, and every reasonable effort must be made to preserve such recordings in perpetuity. I added reasonable effort in there so that cost can be factored into that, because there's a potential that we have old recordings from years ago that we might could get into other format to preserve them better, but the cost may be prohibitive. So that's why that language is there, so that we can help retain our history, but hopefully keep budget in mind as well.
Anybody have arguments for or against? Seeing no other, we'll move to vote. All in favor, please say aye.
Aye.
All opposed? The ayes have it. The motion passes. And abstentions, I think, would be the loudest on that one. Okay. Do we have anything else on Rule 14? Next one we have this. Yeah.
The rule that we just passed require the recording to be publicly available to, publicly available.
General session is defined as taking state language.
Yeah, then we might want to specify that it's public. Yeah, if not, I'll make a motion that we add, let's see, official. I would add for public access at the very end of the sentence.
Are you making a motion for language at the end?
Yes, I am.
For public access? Does that accurately state your motion?
Yes.
Okay. Is there a second?
Grant Dunwoody, Senate 7, second.
Seconded. Do you want to speak to your motion, Rohit?
Yeah, I think it's pretty simple. I mean, the way that it's currently worded, it doesn't make clear that it's preserved for the public. So this is just to clarify that it is.
Thank you. Anyone else?
Point of information, when we say public access, I mean the entire public or Republican Party members or
Public is public.
Because everybody.
I think it's reasonably susceptible to interpretation.
okay.
Anyone else for or against?
I think I'm gonna speak against just because I mean this may be far fetched, but like the state Democrat chair comes into the office and asks for all of our old recording of our convention to go through, or I don't know. But I guess it's already live streamed. Never mind.
We're good.
Mr. Chairman, I'd like to make a friendly amendment.
Okay. Please.
I hope that's a friendly amendment.
Who's speaking right now? Sorry. I can't see anybody like here because
Dave Wilson, SD11, sorry.
so you gotta state your name and SD. Thanks. Go ahead.
Okay, I'd like to modify the um, oh, I'd like to change the public access to a link on the website, on the RPT website. Very similar to the language that we did for the SREC meetings where we had issues with them and what public access was. This is the same language we use from there. Hopefully that'll be a friendly amendment.
I'll accept that, although we might want to change the grammar a little bit. Yeah.
Yeah. Property via. Add a via in front of a.
With appropriate words.
I don't know what's going on right now, but people keep saying words that don't make sense.
I believe what they're referring to is in perpetuity via a link on the RPT website.
Yeah. There you
That's
go.
exactly what I meant.
There you go.
Okay. Amendment acceptable.
Didn't make that a point of
Yes,
anything.
acceptable.
Okay. Any other discussion on the amendment?
I have a point of inquiry.
Go ahead, Chris.
Thank you, Mr. Chairman. Is the link that's suggested on the RPT website supposed to be private or is it supposed to be public?
Via a public link on the website. My God.
I think we have a private section to our website currently. So I think it necessarily by being on the website would be public.
Okay, another question would be, so the intent there would be that anything that goes on in any county or Senate district would be open for review, scrutiny, doxing, um, and whatever other kind of bad act might be gleaned by distractors of the party, Democrats, and whatever else is out there, just for fair game. And that's the question. Is that the intent, just to show the world what happens in every single?
This is applicable only to the state convention.
It says so.
Subsection B.
Mm-hmm.
And any meetings of any committee of the state convention.
Thank you.
State convention.
Anyone else want to speak for or against?
Mr. Chairman, Brandon Moore, SD 21.
Okay.
I'll speak against this, and shockingly, even though I would like as much transparency as possible, um, we have protections on delegate list and everything so that it's for our Republican office holders, party officers, et cetera. We went through that earlier or yesterday in Rule 32. This would put it potentially publicly available to the full general public. And that's the only reason, I didn't include putting it out there publicly, which is why I'm opposing this.
Thank you. Anyone else? Susan.
The only thing about this one that
The only thing about this one that
For or
bothers
against?
me is the
For or
word.
against?
Oh, I am against.
Okay.
The only thing about it that bothers me is the word live stream because we try to get as much income to pay the expenses of this convention. And uh, if we live stream, there'd be potentially a large number of people who would not attend.
That's not. It's already there.
Okay, anyone else? Seeing no further discussion, we'll now vote on the amendment as reflected in the underlined language up on the screen. All in favor of the amendment, please say aye.
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 All opposed?
No.
The ayes have it. The motion passes.
No.
Are there any other further amendments to rule number 14? There's no other further amendments. If there's no objection, we'll move on to rule number 13. Hearing no objection, we're now on rule 13. The next one.
Mr. Chairman, Carmen Calderon, SD 27. I move to add the word or after the semicolon after convention and strike the word and after the semicolon after present and replace it with or in B and C.
Before you
Sorry.
make your motion and it's seconded, I'm going to take 5 minutes. We'll reconvene at 9:10, get a bathroom break. I think it's been an hour, and then that'll allow Rachel to put it up on the screen. So we are at ease, and we will reconvene at 9:10 in 5 minutes.
Yeah.
Hey, Craig.
We can view the battle of legislative priorities and rules committee forever.
Still need a second.
Well, more than the thing.
We're gonna start again at 8:30 tomorrow.
Okay, we're now on Rule 15. A motion's been made, but not seconded yet. Does that accurately reflect your motion, Carmen?
Yes.
It does. Okay. Is there a second? Second, Chuck, Matt. Do you want to speak your motion?
It's just 13, right?
Yes.
Yeah. Okay, yeah, I like to speak to my motion. This has to do with quorum at conventions, and the original language is a little confusing, so I think we need to have this discussion. There's 3 points for the quorum, and it's not clear whether you need to make all three of those points or if they were supposed to be you meet one of those points to make quorum. So to make it clear, I added the word or after each point so that it's any one of these 3 points are made, then you have a quorum of your convention.
Anyone else?
A little background also, I know like at some SD and county conventions, if they're going long, the resolutions report, you start losing people. Someone asks if you have quorum, and then you look at this rule and you're like, well, do we have 50% of the total voting strength? Do we have a majority of the seated precincts present? And then 1/3 of the seated delegates. It wasn't clear exactly what constituted a quorum.
Thank you. Anyone else? Hearing none, we will close discussion and vote on the amendment. All in favor of the amendment, please say aye.
Aye.
All opposed? The ayes have it. The motion passes. Any other amendments to Rule 13? Hearing none, there's no objection. We'll move on to Rule 12. Any amendments to Rule 12? Hearing none, there's no objection. We'll move on to Rule 11. Amendments to Rule 11. There's no objection. We'll move on to Rule 10. The amendments to Rule 10. Hearing none, there's no objection. We will move on to Rule 9, a portion of which is non-amendable. That would be a portion of subsection A prior to the language as REC meetings. The rest of beginning at SREC meetings and subsection B is amendable. Are there any amendments to Rule number 9? Hearing none. Now we will move on. Rule 8A for the benefit of the committee is a permanent state executive committee rule that's non-amendable. So therefore, if there's no objection, we'll move on to Rule number 7.
Point of information.
Yes.
On this suggested change to the RPT rules, it has all these rules, rules 8K, M, N, and O.
We can't hear you.
Oh. On all these suggested rules to the RPT rules changes, there are changes on all Rule 8. Are we not allowed to do that?
Rule 8 we would have to do by a motion to reopen Rule 8, which would take a majority vote. We can do that at any time. Um, what I would suggest is working through these rules. We're almost to the end, and then tomorrow going back to where we need to.
Thank you.
Okay, rule number 7. Do we have any proposed amendments to rule number 7? I think Gene had one. Did he? Get that on the board. We do have some 3A, 2, and what's that? I think it's moved to 1. Right, up there. Let's roll this one.
So they're at the word prohibited, is that it?
Yeah. So what does he have on 2?
Some changes here and there. Participants present. What
It is in front of us.
Yeah, he is probably.
In red on mine.
Yeah.
Mine's, I know how to make it. Yeah, mine's not black. Oh, yeah, it is.
Oh, so probably right before there. I'm gonna come before that 3A because that's gonna be a big discussion. No, we're not going to 8. We already did 8, remember? Yeah. Okay, is that the, Gene, is that your amendment?
Yes, it is. Actually, it's on behalf of another delegate.
Hold on one second. Is there a second?
Second, Parker, SD4.
Second by Mr. Parker. Go ahead. You want to
Thank
speak
you.
to it?
It's simply a clarification that in the case of sub-bullet 5, that it's 1/5 of the members present rather than necessarily 1/5 of the members, total members of a committee. These are the criteria to call a roll call vote.
Thank you.
The entry in sub-bullet 2 is probably not pertinent because participants at a precinct convention are the total participants at a precinct convention.
Okay, anyone else?
Mr. Chairman, Andy Dollar, SE24, just a bit of information.
Yes.
What does Robert's rules say about when you talk about these numbers? Does it infer that they're present when you talk about unless you say something like 1/5 of the members of the assembly or of the delegation? I'm just curious, how does Roberts play that out when you talk about these types of percentages?
Yeah. The answer is a rule supersedes Robert's rules of order. We don't need to follow Roberts. Therefore, if the rule can be clear, that would control. I would say that the first instance in subparagraph 2, even without the change, implies the members present, since it says participants at a precinct convention. In terms of subsection 5, when demanded in writing by 1/5 of the members in the case of a committee meeting, party caucus, or when ordered by, I'm sorry, committee meeting, party caucus. That's unclear.
Okay, thank you.
Mr. Chairman, point of information,
Yes, we state point of information.
Dave Wilson, SD 11. In item B2, is it possible to have participants at a precinct convention that are not present?
No.
No.
Point of information,
Yes.
is the word present in B2 necessary?
Can I answer?
Yes, go ahead.
Yeah, I already said, I'm not sure that that's necessary. I think that the entry in sub-bullet 5 is. I don't think the entry in 2 damages it.
Mr. Chairman, I'd like to make a friendly amendment. Dave Wilson, SD 11.
State your amendment, please.
I'd like to strike the word present from B2.
That, then you just vote against the amendment. That's pretty much it.
It is.
Okay, anyone else for or against? Anyone else speaking? Okay, hearing no more. Discussion's closed. We'll now vote on the amendment. All in favor, please say aye.
Aye.
All opposed? Please stand up if you're in favor of the amendment. Okay, present because stand up if you're against default. Sell your seats tomorrow. By a vote of 12 to 15, the motion fails. Are there any other motions on rule number 7? Seeing none, there's no objection. We will move on to rule number 6. Are there any proposed amendments to rule number 6? Seeing none, there's no objection. We'll move on to rule number 5. Is there any changes to rule number 5? Seeing none, if there's no objection, we'll move on to rule number 4. Are there any amendments to rule number 4?
Oh, hold on. Oh, never mind.
Good? Okay. Seeing that there's none, if there's no objection, you don't need to bring it up yet, because wait, there's more. There's no objection, we'll move on to rule number 4. If you would like, we have an amendment to 3A, we have an amendment to 2, and we have 2 amendments to 1 that the secretary currently has. Given that some of the 3A amendments are extensive, we would debate them now, or we could entertain a motion to adjourn. Not a motion to adjourn, I'm sorry. We would entertain a recess. It's my belief that I think, given the extent of some of the 3A changes, that a recess would be appropriate. So if there's no objection, I would like to recess until 8:30 tomorrow morning.
Point of information, Mr. Chairman.
Yes.
I don't see a Rule 3A in the current rules.
There is no Rule 3A, but we'll be on Rule 3. Therefore, a Rule 3A will be proposed.
I see.
Mr. Chairman, point of information.
Yes.
Is there any, do you know of any motions for 1 or 2? Rule 1 are approved?
We do. We have 2 motions for Rule 1 and 1 motion for Rule 2.
I think we can hammer one of those out for recess.
What's 2? The ones to Rule 1 and 3, I think, are more extensive and could probably benefit by being done tomorrow. If you want to make a motion to take rule number 2 out of order, and deal with rule number 2 before Rule 3, I think that the proposed change to rule number 2 is probably appropriate in scope.
I'd like to make a motion to go out of order and go to Rule 2 and get that done tonight so we don't worry about it tomorrow.
There's been a motion. Is there a second?
Second.
In a second, all in favor, please indicate by saying aye.
Aye.
Opposed? The ayes have it.
Mr. Chairman, Brandon Moore, SD
Mr.
21.
Chairman,
Yes.
point of information. You mentioned that there's a 3A that's going to be.
There's a proposed 3A, which we'll take up under the Rule 3 amendments.
Okay.
What we're just doing is snatching 2 out of order and putting it before 3. So
Is the language available for us to look at that?
it's in the queue, yeah,
It's in the queue.
it is.
Okay.
And if you'd like to review it, Rachel has it. I think she put it on your live doc, right? Yeah, it's in the live doc. And you'll have till tomorrow to review it. I'm not doing it now.
I
Okay, rule number 2. What's the proposed change?
Brandon Moore, SD 21.
Can we get it up on the screen?
Brandon,
Yes, ma'am.
what you sent me doesn't make sense. Said
Oh, it's
rule
it's
2
right here,
in the
right here.
last sentence, right?
Second to last sentence.
Oh, it's the second to last.
Yeah.
Okay.
It's the one about
Thank you. Is there a second?
Katie Jackson, 18 seconds.
There's been a second. Do you want to speak to your motion, Brandon?
Yes, sir. Quickly, this is publication and distribution of rules. They're required to be maintained on the website, can be emailed out, mailed out, etc. What I'm proposing to strike is the last half sentence that requires the state party to maintain an adequate supply thereof of pre-printed rules at the RPT headquarters to fill requests. I feel like this is a holdover from decades ago when printing large documents wasn't so easily achievable. I think we can easily do that on demand as needed, and there's no need to maintain a supply.
Thank you. Anyone else? Hearing no further discussion, we will close discussion and move to vote. All in favor of the proposed change, please say aye.
Aye.
All opposed? The ayes have it. The motion passes. Are there any further amendments to rule number 2? Seeing no further amendments to rule number 2, if there's no objection, we will move on now to rule number 3. Let me make it there first. We are hearing no objections. We are now on rule number 3. If there's no objections, we will would like to recess the committee until 8:30 tomorrow morning. Is there any objection? Everybody? Greg? No. I agree. Hearing no objection, we are recessed until 8:30 tomorrow morning. We're standing at ease until 8:30 in the morning tomorrow morning. Thank you. Yeah, worked out well.
Is this yours? Yes.
Okay, everybody, we're all going over to LP now. George, stop eating. Let's go for freedom.
We also
All line up and like,
We're not.
Stuff.
don't know. Maybe, I mean. Sure, sure plug, everybody, sure plug, yeah, that will.
It's a reader one of it. Saying that authority have to call for roll call. City council president ordered by majority.
All of the,
Well, I just put them away. Right, it's one I should read that would have to. Yeah, I thought it was. Right. Shrink.
it's like workouts.
Rule 3.
They want to ask.
3A, which is the film.
What'll work outside of the room?
It's gonna come up too.
Yada, everybody.
What?
Okay.
May.
Oh, that's,
May 34.
Brandon, this, I'm sure,
Yes.
both those are yours?
Yes.
Okay.
Yeah. There were others. A little further down, 150 members. Right.
Uh-oh.
I look at it and say it's not. Well, I don't know if we have to.
Be there.
And I was.
Then why do you have it?
Okay.
More I can.
I don't swear, like, because it's the law. Next question. Zero thing. Yep. Right. Good. Like, but to, and would you be please,